and it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free.
A little bit, yeah.
Humor me. You look great. Thank you so much. It's better to look good than to feel good. You don't look sickly at all. Okay, I like that.
All right, with the defendant now present, a couple of housekeeping matters. Number one, I wanted to make sure that counsel got the revised charge of the court via email.
We did receive that, Your Honor.
Yes, sir.
And did you guys want me to print you out copies as well? Or did you print copies already?
I didn't print a copy, but I can access it on the computer when we talk about it.
Okay.
Rob, you need a copy?
Please.
I'll get a copy. I'll take care of it. And I know we're kind of in a holding pattern on some of those issues. Mr. Greenwald, have you had an opportunity to discuss with your client about whether or not she wants to testify?
Yes, sir.
All right. And I'd like to go over those questions again.
Yes, ma'am.
All right, Ms. Owens, do you understand that you have a right to testify and that if you want to testify, that no one can prevent you from doing so? Do you understand that no one can make or compel you to testify? That is, do you understand that you also have the right not testify if you do not want to? Do you understand that not your lawyer, but you personally are the one who decides whether or not you will testify? do you understand that if you do not testify, then upon proper request made by you, the court will instruct the jury that your decision cannot be used against you? Do you,
He's has to take everything you say down.
do you understand that if you choose to testify, you will be both examined by your counsel and cross-examined by the assistant district attorney?
Yes, ma'am.
Do you personally want to testify or not?
I will not.
You will not?
I will not testify.
All right, very good. All right, the court finds that the defendant has decided to not testify with a complete understanding of her rights. So I will make the appropriate adjustments to the charge of the court regarding that.
I think I had a request to charge in that regard, Judge.
You did, sir. You did. All right, any other matters to take up before we bring the jury in?
Just that, Brian, you want to let her know about your texting?
Yes, yes. We previously discussed 5 of the autopsy photos that Mr. Greenwald was going to object to. Last night I reviewed those photos and spoke to the medical examiner, and we are going to agree to remove those 5 photos. So they will be not in the same exhibits, they will not be in the PowerPoint. That is going to cause an issue when I give the witness the exhibits. I'm going to skip around the numbers a little bit, so there'll be gaps. The numbers won't be sequential like they should be, but we're taking those 5 pictures out as requested. I also have a question about the charge. Is this the time you want to talk about making changes to that or not?
Now is fine. That'll make for a smoother transition.
Okay. One issue that we have, Your Honor, that we talked about a little bit about yesterday was the aggravated assault charge. I understand that it's a pattern. I understand it's the pattern that we requested. It says, for aggravated assault, the state must prove the defendant assaulted another person with an offensive weapon. And the issue I have with that is that the word offensive weapon, the actual language of the statute for aggravated assault says with a deadly weapon or an object or device or instrument which when used offensively against a person is likely to result in or does result in serious bodily injury. The aggravated assault statute doesn't use the word offensive weapon at all. And I think to use that language in the charge to the jury, it could create confusion because the word weapon is not the same as the word object. There's lots of case law that talks about hands and feet being objects, which when used offensively, or objects that could be construed as deadly weapons, depending on how they were used. But I couldn't find any case law that said hands and feet were offensive weapons. And I think offensive weapon seems like a term of art that could be confusing. I would rather replace that language with the language from the statute of an object which when used offensively, et cetera, et cetera.
Mr. Greenwald?
I don't have a strong opinion one way or the other, Judge. I'm fine with, as long as deadly is not used, because of the way the count is indicted.
All right, I'll make those adjustments and I'll get copies for them. I agree. I think in order to conform to this case, it would be appropriate to modify the pattern in that regard.
Your Honor, now that that change has been made, the state would like to submit an additional request to charge that cites case law that discusses hands and feet specifically because those are the allegations in this case. I didn't print a copy of this. I just had it typed up this morning. Can I print it out and show it to y'all real quick or send it to you?
Why don't you email it to Tracy?
Yes, ma'am. And Rob. If I send it to you, can you see it? Do you have any like?
Yeah, I'll open it.
I'll get a copy for him.
Okay. It's just case law that says hands and feet when used offensively, et cetera.
All right, anything else?
No, Your Honor.
Mr. Greenwald?
No,
Let me just step back really briefly and get this to Tracy and let her know what's going on. And then she'll be expecting the email and get copies now. Okay?
Yes, Your Honor.
Right back. Are you ready for the jury?
Yes, Your Honor.
Yes.
You have more moments than usual.
Strategic.
More sniffles.
I'll give you a hug later.
All right, good morning, ladies and gentlemen of the jury. Everyone have a good night's rest? Very good. All right, the state call its next witness, please.
Yes, Your Honor. The state calls Dr. James Downs.
You can use ClickShare.
I'm going to use the hard wire just to make sure we don't have issues.
Good morning, Dr. Downs. Do you swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir.
Good morning, Dr. Downs.
Good morning.
If you would, please just say your name and spell it for the court reporter.
James Claude Upshaw Downs, MD, DOWNS.
Thank you, sir. Where all are you employed?
I've worked several different places. I'm here today as an associate medical examiner for Gwinnett County. I also work in Charleston, South Carolina as a coroner's pathologist. Additionally, I work as the medical director for the physician assistant program at Charleston Southern University. And also, I'm a medical legal consultant. I have a consulting business.
How long have you been employed in these various roles?
In all of those different.
Yes.
So I started consulting while I was working my last job. So that was probably 90, 91, something like that. Started working for the Gwinnett County office in 2017 and started working at Charleston, I think, 2020. And I've been doing medical examiner work for 35 years.
Please tell the jury about your education background and training.
I got my Bachelor of Science degree in biochemistry, magna cum laude and Phi Beta Kappa from the University of Georgia. I did my medical school training in Charleston, South Carolina, my hometown. I also did my residency training in anatomic pathology and clinical pathology. That was also at the Medical University of South Carolina. I did my fellowship in forensic pathology again at the Medical University of South Carolina. That did include a month in the Dade County, Florida, the Miami Medical Examiner Department. In addition, during the course of that training, I did an internship at the FBI Behavioral Sciences Unit in Quantico, Virginia. Since graduating the residency and fellowship, I've done continuing medical education on an annual basis ever since.
Is performing autopsies part of one or more of your jobs?
Yes.
How many autopsies would you estimate you've performed in your career?
Personally, I've probably done something like 8,000. I've assisted in another couple of thousand. In my former job as the chief medical examiner for the state of Alabama, we did something like 1,500, 2,000 postmortem cases a year. All told, I think it's safe to say that I've been part of 16, 17, 18,000 postmortem cases.
Have you ever testified at trial before?
Many times.
Have you ever been qualified as an expert in forensic pathology at trial?
Many times.
Can you estimate about how many times you've testified as an expert in forensic pathology?
I can tell you that it's probably hundreds. I've given sworn testimony in 20 different states, in federal courts, for military tribunals, including the Air Force, the Army, the Coast Guard. I've also given sworn testimony before committees of the U.S. House and U.S. Senate, and additionally before the National Commission on Forensic Sciences.
Your Honor, this time the state moves to tender Dr. Downs as an expert in forensic pathology pursuant to the questions we just asked and the stipulation of the parties.
Mr. Greenwood?
No objection, Judge.
He's qualified as an expert.
What is the purpose of an autopsy?
I guess the main purpose is to determine what happened to an individual, cause and manner of death. In addition, if there's any information to be gained in addition to specifically cause and manner, to gather that. If it's a case where there's evidence to be collected, to gather that. That would be, for example, photographs, if there are injuries, if there's trace evidence, to collect anything like that.
What does cause of death mean?
Cause of death is the initial event that set in motion the unbroken chain of events that ended in death. In other words, something happens, there's either it's immediate or there's a time, and then the person dies. So the cause is this over here that started that whole chain going.
What is manner of death?
Manner of death is the circumstances under which the cause happened. So there's 5 different possibilities for manner of death. Natural, self-explanatory, you have a heart attack, natural death. Accident, something unforeseen, reasonably unforeseeable. I could leave the courthouse and get hit by a bus. That's unforeseen. Suicide, death by your own hand. Homicide, death by the hand of another. And that can either be active or passive. For instance, neglect. Active neglect, that act is a homicide. And then finally, if you can't tell, undetermined.
Are autopsies only performed for homicides?
No, probably most of the cases we do these days would either be natural or accident.
When bodies are brought to the morgue for an autopsy, are they assigned a case number?
Yes, they are.
When a body is received, are you given any background information on the body?
Yes, I am.
Why is that information important?
Well, I mean, you've been to the doctor, and the first thing that happens to you when you go to the doctor is, why are you here? As a physician, I need to understand the questions that are being asked so that I know what tests to perform, kind of an idea of what to look for, either to include or exclude. So it's critical that I have some kind of information. And even if I have no information, that does help me kind of a little bit tell me what I need to look for in this case. So the more information I get, the better.
Does the medical examiner's office have investigators?
Yes, we do.
What do they do?
They are my eyes and ears at the scene. Because there are only 2 of us who work at the ME's office here in Gwinnett, we can't go to all the scenes. So we have multiple different investigators who are highly skilled professionals who go to a scene, assess the scene, determine preliminarily what they think might be what happened, and then send the case in or decline it, because we don't bring in every single case. There are cases that don't need an autopsy. There are cases that don't even need an external examination. Then there are other cases that clearly need an autopsy in order to find out what happened.
Do the investigators document what they see when they go out to the scene?
Yes.
How do they do that?
They do that by means of photographs, multiple photographs, as well as a written report.
And do you review the photographs and the reports prior to doing an autopsy?
The report usually is not written by the time I do the autopsy. The photographs may or may not be reviewed before the autopsy. It really depends on the circumstances.
Can you walk the jury through the steps of conducting an autopsy in general?
Sure. So we've been through kind of the preliminary. I get a story. I get some history. And based on that history, I kind of set in my mind, okay, here's what I'm looking for. This is going to be an external exam, or this is going to be a full autopsy, and it's going to require lots of documentation. The case we're here about today is one of the latter. It's going to require a lot of documentation. So I go in, we open the body bag, pictures of the outside of the body, and then I start looking on the outside of the body to see if there's anything that I think is important. For instance, here, the body is in plastic bags. Okay, that's important, the fact that the body's in plastic bags. So we'll dissect away that layer. Then we'll look underneath that layer. Oh, there's ties around the waist area, the hips, and the arm is tucked under here. And there's another plastic bag tied around the waist. Document all of that. And then we'll kind of go through that process, removing, if there's clothing, after I've looked at the clothing and determined whether or not there's evidence I think is important, we'll go through that. If the body is received wrapped in a sheet, we'll keep the sheet in a case like this, and that'll get transferred in evidence. And so it's a very methodical process. It takes a long time. The outside of the body, the skin is the biggest organ in the body. So believe it or not, usually the outside part of the examination is what takes the most time, because I'm very meticulous, very thorough. I look at everything. Once I get all of that external done, I've collected whatever external evidence. For example, a sexual examination kit, I might do that. Once all of that's completed, we'll then clean the outside of the body and then look again. Basically start over and go head to toe, looking for anything that might be there, front and back. Once I'm satisfied with that, I'll then proceed with an internal examination. And that's an incision, shoulder, down to the middle of the breastbone, and then down the front of the belly. From that, the rib cage is removed, or the front of the rib cage is removed. Examine all the organs in the body and dissect those out, usually one at a time, depends on the circumstances. If I need to keep something together, I will. If there's evidence there to be seen in the organs, like in this case, I'll take individual organ photographs. I'll collect, like in this case, if there's blood collected somewhere, I'll collect and measure that. During the course of this process, depending on what's available to me, I'll collect toxicology samples, so blood or urine, to look at to see if there are any drugs there. Once I complete that part of the examination, I do have an assistant who's helping me with the organ removal process. We're working side by side, but while I'm looking at the organs individually, they will be preparing the head for examination. So they'll make an incision between the ears and the back of the head and dissect the scalp away and basically flip it forward like this. So the scalp is reversed but laying over the face. Then using a saw, they'll make a circular cut around the skull, remove the brain. And of course, I'm here looking at the steps. If there's something to document or see, we got photographs because there's multiple people in the autopsy room with me. Once we complete that part of the process, the brain is removed, and then I look at the brain, and depending on the type of case, the airway. We may do that next to last or last. It just depends on the nature of the case. With the airway, we'll take this flap that was in the front of the chest and dissect that up. So the flap that was here where I made the incision down to the breastbone, we'll take that skin, dissect it back so it again lies over the face, and then remove all the neck structures except for the blood vessels in front, up to the tongue, including the tongue, and dissect all of that out. And then I'll look at that as well. Once I have looked at everything like that. I will take microscopic sections, and I may take those along the way if they're external injuries or internal injuries that I think I need to document with a microscope. I'll go ahead and take sections of those, and then I'll look at those microscopic slides, send the toxicology out. If there's anything else to examine, I'll do that, and ultimately I'll end up with a written autopsy report.
Now we're going to get to the case at hand for today. Were you asked to perform an autopsy on Amari Hall in November of 2021?
I was, November 24th.
What background information did you receive when Amari arrived at the morgue?
Basically, the thumbnail sketch was there was this young girl, appeared to be very young, less than 10 years old, who was found in plastic bags in a wooded area, and she appeared to be malnourished. That's kind of the thumbnail sketch. There were multiple obvious injuries externally.
And was she assigned a case number?
She was.
What is that case number?
Give me 1 second. I blanked on the number as I'm sitting here. 1 second. That's 21G 2057.
I'm going to show you what has been marked as State's Exhibits 175 through 184, 186 through 193, 195 through 210, 212, 213, 215, 216, and 218 through 226. We'll thumb through these and then give them back to me. These will previously shown to the guys. Do you recognize those?
I do.
What are they?
These are some of the photographs from the autopsy of Amari.
And are these fair and accurate representations of Amari's body as you viewed it when you did the autopsy?
They are.
Your Honor, this time the state moves to introduce into evidence, tender into evidence states 175 through 184, 186 to 193, 195 to 210, 212, 213, 215, 216, and 218 through 226.
What was the last number? Was it around 218 through
226.
226? Previously, seen the judge, no,
Admitted without objection.
And may I publish these exhibits, Your Honor?
You may.
Dr. Downs, did you create a PowerPoint containing several of the state's exhibits as well as some diagrams that you believe will help explain the injuries in this case to the jury?
I did.
We have the HDMI input up, Your Honor?
It is.
Okay, just making sure.
Way ahead of you.
Thank you, ma'am. What information is contained on this slide, Dr. Downs?
The case number up at the top, 21G2057, Amari Hall, her date of birth, 10/30/13, date of death, that's the date that she was pronounced, not the actual day that she died, was November 23rd of 21, and pronounced at a little before 1 p.m. I did my exam the next day at a little before 11:30 in the morning on the 24th, and cause of death, multiple blunt force injuries, other significant conditions. Those are things that aren't reflected in the cause, but are also important in her death. And those other conditions were battered child syndrome, malnutrition, and the manner of death, homicide.
Can you define battered child syndrome for the jury?
That is a description to describe multiple wounds in multiple locations in multiple stages of healing. That is a child who has been abused with injuries in multiple different areas that happened at different times, so different episodes. And they're in multiple stages of healing in multiple different areas on the body.
What is a blunt force injury?
So there's several different big categories. A gunshot wound is a type of injury. A fire injury, a thermal injury is a type of injury. Blunt force is by a blunt, a non-edged weapon. So a sharp force injury would be like a knife, glass, something like that. Blunt force would be like a baseball bat, a brick, any broad, flat surface. Doesn't necessarily have to be broad, but a flat surface. And there are three types of wounds that happen. There is a bruise, medically we call that a contusion, but it's the same thing. An abrasion, that's like when you fall on the sidewalk and skin your knee, that would be an abrasion. And the last type is, actually there's two others, but they're both lacerations. Laceration is a physical tearing of the tissue, ripping the tissue. So on skin, the skin wound would gape open. You can also lacerate bone, that's a fracture.
You mentioned baseball bats when describing blunt force injuries. Could the floor be part of a blunt force injury?
Sure, it's a broad, flat surface, absolutely. Abrasion, like you fall and skin your knee, that would be an abrasion, a blunt force injury from the floor as the offending weapon.
Could hands and feet cause blunt force injuries?
Sure.
We're going to go to the next slide. This is State's Exhibit 140. What are we seeing here?
So this is Amari's body. She's in plastic bags. You can see covering her upper body down to just above her waist. At the waist area, you see another plastic bag that's tied around the waist, and within that, there's plastic about a yard length of black fabric that's been tied, involving that second plastic bag. And then the third plastic bag goes from the thigh level down and covers the feet. So she's been placed head to toe in two plastic bags, and they've been pulled away from the midsection, so you can see her butt would be towards us as we're looking at the picture. Her thighs would be going away from us. She's laying on her left side.
This is State's 175.
So this is a close-up kind of the same area we just looked at. Instead, we have now turned the picture, so if we were looking at the picture before with her butt in the foreground, we just turned the picture like this and walked in and got a closer picture. So her butt is now to my left, and her thighs are at the bottom going to my right. You can see that plastic bag that's tied around her waist, and then the black cord, that 3 foot or length of cord that's tied in that.
Dr. Downs, there's a pointer just under this monitor here if you would like to use that, if you want to stand up.
Thank you.
Your Honor, is it okay if he gets up?
He may.
Thank you.
Thank you.
What was the significance of this photo in your investigation?
So, as I mentioned, we want to document what's there, what we see. The fact that somebody has been, the body has been disposed of within plastic bags, that's a purposeful act. That didn't just inadvertently happen. She was placed inside these bags. The fact that this is knotted, this third bag is knotted and tied around and the black fabric is also knotted together. That took time and effort and thought. That didn't just happen.
Okay. Moving to State's Exhibit 176.
So now the bags have been pulled away. You can see down here toward her feet area. And the notable thing to me here is we've got some scabbing here, so older injury on the ankle, the outside of the left ankle. In addition, there's a linear mark here, and you can see a finger linear mark here. Those are consistent with binding, like somebody tying her legs together. And since it's old, it's healing. This didn't happen around the time of death. This happened before. Now, there may also have been other tying around the time of death, but this is fresher or older than that.
Are you able to say how old it is or no?
Not really. It's not that precise. I can only see that I see evidence of healing here. I see scabbing. I see red margins. Those are all signs of body reacting. So it happened earlier. May have been multiple episodes, but there's definitely one here, and then this may be fresher over the same area.
This is State's 177.
And we see an abrasion here, again, rubbing of the superficial skin surface. And again, you see that same horizontal linear pattern. This is on the right lower leg, and you'll see multiple parallel lines. You can also see them up higher. I didn't have any corresponding ties or ligatures around the legs. This looks like it's scabbing, so again, this is an older injury. This wasn't when she died. This happened days before. It wasn't right around the time she died. This is not that same day.
You said ligature. Is that just like a rope or some of the other
Yeah,
things?
a tie. So anytime I use that word ligature, and I apologize for the verbiage, it's kind of how we talk about stuff. So if I can, I'll just refer to like a rope or something. So that may be easier.
Well, you can say ligature now that you told us what it means.
Okay.
All right, this is State's 178.
So here, this is from her left side, and the most notable thing to me is how skinny she is. She is remarkably skinny. When you compare her to height, she's very tall for her age, but she's also very thin. So when you put those two together, she's less than the 5th percentile. So you know those big bell curves where you have everybody 50% is in the middle? She's way over beyond the margin, beyond the curve, past 2 standard deviations. So she's unusually skinny. You can see her ribs sticking out. You can see how narrow her waist is. This child's been malnourished, hasn't gotten sufficient food. Beyond that, then I start looking, and I'll just start at the head. I see some dark discoloration around the eye. I see some open defects. There's a dark discoloration here on the chin. In addition, there's a healing laceration on the underside of the jaw. And you'll just notice as you go down, multiple, the lighter tan, pink, those are areas where the skin surface has gone away. And once you get past the very superficial surface layer of skin, all the pigment cells are in that layer. So once that is abraded away, once that skin surface is away, everybody has that same color as the subcutaneous, underneath the superficial layer of the skin. And you can see, again, just going down, multiple different wounds, abrasions, some excoriations, which is a different type of abrasion. Again, the skin surface is gone. A deeper healing wound here on the left wrist, a very large grouping of abrasions here on the left thigh. You can see some stuff going on in the abdomen and some stuff over on the other arm.
Moving to State's Exhibit 179.
So this is the same general area, but you can see better here. This mark on the belly we'll come back to. And if you look, you'll start to see what look like maybe some bumps over here on the side of the chest, some darker areas of skin that I can't do a whole lot with. I want to look at that when I get the skin surface off. So that's what I'm focusing on in this picture, just the darker areas to try to determine, okay, what is this that I'm looking at? And I also have to remember that she's been out in the woods for a while. So one of the things I have to think about when I'm doing my exam, is this a real injury? Or is this from animals coming after the fact and eating on the remains? I have to be cognizant of that. I do know that there was a 5 or 6 inch hole in that bag around her face that gave animals access to her face. So I know there's facial stuff that's artifact.
This is states 180.
This is on the right arm, and you see an older scarred injury, linear. That could be from something like what I'm holding in my hand, hitting the upper arm and causing a wound that's scabbed and healed as a scar. And then the other stuff down below that we already looked at.
This is states 181.
And this is a closer up of that area on the left back of the forearm. You can see here where you've got an abrasion or an excoriation here. You've got the same thing here, but this is healing. The edges you see are kind of a different color, and they're a little heaped up. So these are healing wounds here, some healing here. This is healing. And then you've got some scabbing here and some blistering here that's non-specific. I can't really do anything with that blistering.
This is states 182.
This is down now on the left hand and left forearm near the hand. You can see a healing erosion, ulceration on the back of the left forearm and some scarring on the back of the hand.
States 183.
This is on the left upper arm. Now, we looked before on the outside. This is on the inside, and you see a linear, what looks to be an abrasion. It could be a healing abrasion there on the arm, and also some darker discoloration closer to the elbow, and then some likely artifact down there at the elbow crease.
States 184.
This is the, I believe, the inside of that left forearm. Again, some blistering. I can't do a whole lot with that. Some scabbing and healing here, scabbing and healing, and then this we didn't see before at all, scabbing and healing here. So all of these, again, older injuries. This isn't what happened the day that she died. This is earlier, there's scabbing.
When you say you can't do a lot with the blistering, what do you mean? You can't determine where it came from or what?
I don't want to overcall something. Okay, I want to tell you what I can see as a forensic pathologist. But I also don't want to tell you this is a wound and it's not be a wound. So there are some things that I'm going to say I don't know, because I don't. And I don't want to give you the false impression that I have all the answers. This child has so many different injuries and artifact. Artifact is something that looks like it could be an injury, but it really is not. I don't want to mislead you and tell you these artifacts are real injuries. They're not. So if I can't tell you, I'm going to say I can't say. They could be, they could not be. There are stuff that clearly is artifact. And if I can tell you that, I will.
Thank you, sir. This is states 186.
So now we're going more to the front. And thing we see a little better here is that mark across the abdomen. Again, that's a very linear mark. That could be, again, something like a cylindrical object like the pointer that I'm holding in my hand. It's taking the skin surface off here. There's some, looks like there's probably some healing here, but that's an abrasion. And then more other injuries trailing off the abdomen. This crosshatch area in the right upper abdomen, and that's important because that's where the liver is. And as we get to the inside of the body, that'll become obvious why this area at the liver is important in this case. Then going over to the right arm, we can see the same kind of pattern we saw on the left. Multiple different wounds, multiple different locations, multiple different stages of healing. In addition, I mentioned the laceration under the chin. You can see that better. There's what looks to be some artifact around the eye here. So that's not real. It looks like it could be something. It's not. It's just not. Very typically, animals will come in and they will eat around the eyes. They'll eat around the mouth. So we kind of expect to see those types of injuries in those locations.
This is states 187.
Again, I'm specifically drawing your attention to here, this crosshatch type pattern here in the right abdomen. That's my main focus here. We saw also earlier this injury on the left thigh that's kind of coming to the front a little bit here.
States 188.
And that's specifically a different angle. There is some type of pattern here. A pattern injury would be like you're walking on the beach and you look down and you see a footprint. You know it's a footprint. It looks like a footprint. You may not be able to say whose foot it is. Probably can tell it's a left or a right foot. But sometimes there's so much detail, I can tell you it's a Nike size 10.5 and it's this particular brand or this particular model of a Nike. That's not what's happened here. Something caused that, something has a very distinct pattern. If you gave me 10 objects and one of them included this, I should be able to say, oh, of these 10, I think it's that object. I can't do that here because I don't have the 10 objects. So I recognize there's a pattern of something here. I just don't know what.
What type of injury is that? Is that a burn or an
All right,
abrasion?
so this is an abrasion, and it's deeper here where it's lighter pigment. It could be a burn. If you got a surface hot and branded somebody, it certainly could cause something like that. I can't tell you that that is a burn.
States 189.
All right, so there are a couple of things that are notable here in addition to some scarring, again, older injuries. What struck me here is the lack of muscular development. She's just got no muscles because, again, I think she's malnourished. And you see these bony, knobby knees in a little kid. That's very unusual in my experience. So that's really what stands out to me here.
States 190.
This is moving down the legs. Again, you see some scarring. You see scabbing, so older injury on the outside of the ankle. This is what looks like a ligature mark, and it's healing. So an older binding injury.
191.
This is just coming in closer to show you that that is in fact a scab. And that's pretty well along the way of healing.
States 192.
This is closer up on that area of healing here. It looks like some scabbing here. These two look like different ages. It could be that they happened at the same time and that this was just a deeper open wound and this was more superficial. But this broke the skin, and it's an older injury. At least one.
States 193.
Looking at the top of the left foot, we've got an area of blistering here. That's the outside of the ankle. And this old circular healing injury on the top of the foot. That's not an easy place to injure. Not an easy place to injure. Several different things come to mind as to what might have caused that, but I can't tell you what did cause it.
This is States 195.
So here, you see these lines here, all that's artifact, okay? That's like a cat or a dog or something clawing at the face. Likely, these are teeth. And then you come up here, and this is what stands out to me most of all. That's a laceration or a tear of the frenulum, the inside of the lip. That is commonly seen with a punch to the face.
States 196.
So now we're looking at the lower lip, and again, you see this stuff that's artifact, but in the middle of the lower lip is a very large laceration. And that is not artifact. It could be that something is eating at a prior injury, but to go to that location, in my experience, would be unusual. So I believe there's an existing injury at that site as well.
Meaning it would be unusual for an animal to get into that area of the body. Is that what you mean?
Animals are lazy. They're going to go where the food is readily available. That's why they go to the eyes and the mouth. Because when we die, we leak blood, which is attractive for animals to eat. And so they'll start there. If you have a wound, that's where they're gonna start eating. We call that inappropriate decomposition, because we know patterns of how bodies decompose. This is not a normal pattern of decomposition, so I believe that an animal ate an existing wound there.
Stage 197.
So we're looking at the front of the neck here, and it's scaly up here at the top of the neck. You can see the laceration on the underside of the chin, and then there's some superficial stuff here. I can't tell you exactly what that is, and then you see the pale scars.
Stage 198.
This is the left side of the neck. You can see the darker discoloration here. Sometimes it's hard to tell externally if there's an injury there or not. There's not any specific injury here. But the scaly skin surface is what draws my attention. I'm also looking to see ears. Ears are common areas that are injured in child abuse cases. People will grab the ear, pop the ear. So we always look at the ears to see if there's anything there, and you can see a little abrasion there.
Stage 199.
Looking at now at the right side of the head, and there's injuries here to the outside of the right ear. There's also some you see later to the other side. And that's the main purpose here, as well as this linear mark on the neck. Now that is something. That is not a pattern of discoloration or something. There is an existing injury there.
You mentioned that we might see later what's under the blue square there. We're going to save the jury from showing them that again. Can you just describe the injury that's on her face up there?
So the blue square is what you're
Yes,
talking
where the
about?
blue square is.
So animals have basically taken that whole everything that's covered by the blue for the most part, animals are eaten.
Thank you. Stage 200.
So same thing here, and I'm coming down. Now I'm looking at the side, because one of the things about interpreting injuries is I want to do a three-dimensional look at things. We live in a three-dimensional world, so bodies are three-dimensional. So even though it's a similar picture, it's indifferent. And the difference is important because bodies are not flat. So I have to look at this in the context of, okay, I've got the rib margin here, and I couldn't really appreciate that the other way, how sunken this is. So it allows me to do that. It also gives me a look at how skinny her belly is. And I'm looking better at the right side here. I'm also looking down here at the right leg, and a different mark, different pattern on the right arm. Again, you start seeing now, you've seen several of these before, that horizontal linear pattern with an erosion that's healing. Again, around the forearm. This looks like a ligature, a binding injury. You've got some other stuff here that's higher up. That could be binding. It could also be with a rod-like object that's broken the skin. This has some healing associated with it. Scarring here, so different time window here, and then vertical. All right, so this is an object that hits and then changes direction. So that's not one, unless you've got some weird object that has these four lines. That's 4 different blows at a prior time.
Stage 201.
So now I'm looking at specifically at the thighs, and again, what draws my attention here is her lack of muscle development. It's striking to me. Here, I've got some abrasions, but I also noticed that for the most part, her legs are spared. That's important to me, because in interpreting injuries, why would somebody's arms be involved and her legs be spared? And there's something that we call defensive injuries, where a subject that is being attacked tries to ward off blows. And there's basically only 2 things you can do. You can cover either side of your arm, could be the surface to your assailant, or you can try to punch back, which is going to be really hard for a weaker subject to do against a stronger assailant.
Stage 202.
Moving down, again, to remind you of these marks on the lower legs, and they're on both sides. And I mentioned just now defensive injuries and why you might only have them on the upper extremities. If your legs are bound, they're not going to be a good weapon to fend off blows with, leaving only your arms free to potentially fight off blows.
Did you see those ligature marks on the insides of the ankles as well, or just the outsides?
I believe they're just on the outsides, and if you think about it, if you're trying to get out of ligatures, you're not pushing together, you're pulling out, so the ligature would bind or rub on the outside.
States 203.
So here we've got multiple linear scabs, so this is not artifact. You've got some scarring here with hyperpigmentation. The skin gets a little darker around that. That's common in people with darker skin. If they get an injury, sometimes it'll come back and it'll be lighter, and sometimes it'll be darker. So that's what I'm looking at here. I've got another injury here. Again, that injury around the neck. And then an old linear mark here on the upper arm. And what looks like a darker area, that could be a bruise right there.
States 204.
Again, looks like, I believe the right arm, and just closer up showing you these overlapping linear patterns that have that same scab on one end and deeper healing injury on the other.
States 205.
This is a close-up on that right neck injury. I see what looks like some scabbing up at the top. And I can't tell you specifically, that could be something around the neck, a ligature around the neck, but it doesn't go all the way around. It could also be a blow with, again, a cylindrical object like this. That's just so nonspecific, I can't tell you what caused it, but something caused it. Some injury caused that at a prior time.
States 206.
Looking, I believe we're down to the legs now, and area around the knee. Again, the same pattern we've seen over and over again. Scabbing with a deeper healing injury associated with one end of that. Linear, generally speaking.
States 207.
Looks like a healing injury here, and then multiple areas of scarring on the palm, and it looks like a braided area here, closer to the thumb. So palm injuries. Typically when you fall, we have a reflex called the parachute reflex. When you fall, your hands go out to protect you. So that could be from that process, or they could be specific inflicted injuries to the palm. I can't tell you which.
States 208.
This is showing now more to the lower right side of the abdomen. Again, the same type of pattern. So it looks like we're seeing that same linear mark, deeper on one edge, healing on the other, as though you were hitting with a rod, and it goes deeper on one edge, and then where there's less contact with the skin surface, that's the scab part. So the deeper part is actually ulcerating the skin.
States 209.
Broader abrasion, non-specific, that could be anything. It could be from the rug on the floor as the child's going down, and then multiple smaller that I can't tell you what caused those.
States 210.
I told you we'd come back to the right ear. This is the right ear. You can see an area of erosion here, abrasion behind the right ear, and then deeper closer to the bottom.
States 212.
I think this is to illustrate just a little different view here and to show you that I don't see any continuation on the back side of the legs.
States 213.
And the same thing here, I'm looking around to follow these marks to see where they stop and where they continue, and also to see if there's any defense or injuries consistent with defense on the backs of the legs, different views of the legs as we go around the circumference.
States 215.
This is a close-up, the lower right leg, showing the scabbing, multiple linear, and very limited. Again, it's that area and no other on that leg.
Stage 216.
This is a scab, I believe, on the outside of the right leg and a small scar. Now, this is the type of thing you'd see in a little kid. Little kids, I've had 4 of them, they fall down. They get boo-boos. That's what I would expect to see. Now, that's a pretty significant scar, but you can get that accidentally trip and fall and cut your leg.
We've seen a few photos now that have the ruler in there. What's the purpose of measuring the injuries?
So that's a standard ruler. It's called an ADFO number 2 ruler. It is a standard ruler used worldwide. It's got these quarter-sized circles here, so you know what plane the ruler is in, and it's very specific. You've got 1 centimeter gray, so you know, I believe that's 18% gray, so we know what the contrast is in the picture, and then 1 centimeter black and white alternating with millimeter gradations, and just because I have a hard time keeping it in my brain, a centimeter or 2.5 centimeters is an inch. Okay, so if we go to 3.5 or 2.5 centimeters, that's 1 inch. That gives us an idea between here and here, and here and here. That's about 2 inches.
Stage 218.
And also, I should mention the, if you go back
Yes,
just a
sir.
second, I forgot to mention. So you'll also see, we'll have that number with the case number in the pictures. This is the ruler that we use as we go around and take all these pictures. We put the ruler in there so we know it's this case.
All right, back to 218.
Again, we're looking again around the legs. I'm also looking at the feet, and we mentioned the scar on the left. We've got one on the right in a very similar area. I really don't know what to make of that. I don't know if that's maybe ill-fitting shoes. I don't know if there's an injury that was inflicted there. I can't tell you because it's scar. There are weapons that cause very characteristic circular scars. I can't tell you this was caused by a weapon. I can only tell you it's a circular scar.
We are going to move to internal now. This is stage 219.
So this is the most striking part of the autopsy, visually. I make an incision after we did all the external examination. We went to the internal examination. I make an incision in the belly, and immediately, this is the belly. The pubic bone would be down here. The edge of the rib cage would be up here on both sides. In fact, you can see it right here. That's the left rib cage going up. The liver, and there's all of this blood in the belly. That doesn't belong there. Blood should be inside blood vessels, and this is not only liquid blood, there's blood clot inside the belly. So now I know there is a significant injury inside the body.
And then we've
you can
added,
see-
added stage 220 to the
Sorry.
side.
So over here, that's the blood that's here. I pulled it out, and I quantified it at 120 milliliters, about 4 ounces.
Stage 221.
All right, this is the right lung, and there's bruising to the right lung at the point of attachment. So there was significant blunt force injury to the chest, sufficient to cause bruising of the right lung deep inside the body, right at the midline. That is a very significant force.
Could being squeezed between 2 hard objects cause that kind of injury?
I would say it's possible. I would prefer some type of forceful motion, for instance, being thrown against something, because basically all of the organs inside the chest are free-floating. They're attached at the top at the airway and attached at the bottom with blood vessels and go to the liver. If you throw somebody against the wall and say they're going, for example, 10 miles an hour. Their body hits the wall. Their internal organs are still going at 10 miles an hour. And so they stretch the tissue. This is the main stem bronchus, the airway. And that's where this bleed looks to be originating from. This is not from a direct blow. Could be from a crushing injury, but I would actually favor a motion injury here.
This shows stage 222. and I think with 221 as well, right?
Sure, yeah. So this is the liver, and there's a 3-inch laceration, a 3-inch tear in the liver. Associated with that, and this is different blood volume than what we saw in the belly, because I can't really quantify it. You can see a significant amount of bleeding associated with this. In addition, it looks like there's a little bit of reaction here. So that tells me this injury has been there a little while in order for white blood cells to come in and collect pus. That could be a couple hours.
Okay. And what's the bottom right picture there?
This is the back of the liver. This is the gallbladder, which would be sitting about right here. And you can see the bleeding into the back surface. The darker discoloration here could be blood settling with gravity, livor mortis. We also see an area of bruising here on the left liver.
Are these injuries to the liver what would have caused the bleeding we saw earlier?
Yeah, the blood that we saw in the belly came from this. There's no other source for the blood in the belly.
Could this be caused by a crushing injury or a direct blow?
Direct blow, and if you'll remember, I drew special attention to that cross-hatched area in the right abdomen at the edge of the ribs. I think that's what caused this. And I would favor something like a crushing injury. Given that you have that crosshatch pattern, I would say it could be a footwear, a shoe, a boot, could be a foot, and we just have a secondary injury over the top of that. But something hit the outside of Amari's body and crushed her liver against her spine.
Could this injury have been caused if the child was laying on the floor and was stomped on?
Yes. That would be an easy explanation for it. That would make sense.
This is states 224 and 225.
So we're looking inside the body. I mentioned at the process of the autopsy, we remove all the organs out. So this is the body, all the organs removed out, and toward the midline here, we're looking where the spine would be. This pale tan thing, that's the aorta, the big blood tube that runs from the heart to the rest of the body. So that's the midline. And over on the right side, at the 5th rib in the back by the spine, there's a healing fracture, old injury. On the left side at the 7th rib, there's a healing fracture, different age. Multiple wounds, multiple locations, multiple stages of healing. Clearly, right and left, back, and on the side. These are different wounds, same type of wound, they're both fractures, but they're healing differently and in their different locations. Again, this is part of that battered child syndrome.
I want to jump back, if I can, to the liver injuries. Would there have been any outward signs on the child that this injury had occurred?
I would expect it to be painful. I would expect the child to at least be complaining of abdominal pain, if nothing else.
Is this a survivable injury?
Yeah. You take this child to the hospital, they make a foam, they call it gel foam, and you just pack the wound, it causes the blood to clot. That's perfectly survivable injury if treated in time.
And when you say in time, how much time do you think it would have been?
It's hard to say with precision. The sooner the better. And I would think that this injury would be immediately noticeable by outward signs from the child, like pain. So I can't tell you like 32 minutes, that's too much. I can't do that. But I can tell you that you get the child to the doctor within a couple hours of this, depending on the rest of the case, this is potentially survivable.
Now we're going to move forward to states 226.
So as part of doing the autopsy, I mentioned we'll do an incision in the back of the head. This is the left back of the head. So inside the hairline, and there's this large area of bruising that's visible underneath the scalp. You can see the outside here, the hair. So there's a large area of bruising, and this is the same bruise as that. There's a smaller area of bruising over here, but this is a fairly significant bruise to the left back of the head.
Was that injury visible on the external examination?
No.
Okay, what are we seeing here?
So as I mentioned, Amari was very small, very tall, over 95th percent for height, but 54 pounds. So that's low end of the spectrum for weight, but based on her height, she should weigh a lot more, right? Because she's very tall, her weight should be somewhere close to that 95th. I mean, doesn't have to be 95th, but 75th. Instead, she's down on the opposite end, and if you put those two together, height for weight, she's less than 5th percentile. She's malnourished. And you saw that visually.
What are we seeing on this? You mean put them all up there or just one at a time?
One at a time will be fine. So what I did is, there's a lot of stuff here. And so I tried to separate out the injuries as to, this is critical. This is something that this person could die of in and of itself. Here she died from all of it. But this is stuff that she needs to get attention for now, if she's going to survive. So the 3-inch laceration on the liver, and I pointed out that 3.5-inch clot that was over it that had some signs of reaction to it. And then there's another bruise, 3/4 of an inch, and bruised liver tissue. So that's the thing that gets, I think, your most acute attention. If that's untreated, you're going to bleed to death. So 4 ounces of blood in the abdomen, that's all associated with that. Okay, so that's critical. Then I said, okay, what are the injuries that, these are fresh, I don't have any doubt that these are fresh injuries that happened around the time she died. And there's a bruise on the central lower lip, 1/2 inch, a little bit bigger than 1/2 inch on the left lower chest. That crosshatch group on the right, and again, that's fresh, which is why it caught my eye, and I thought about that as being that, I think you said stomping, that type of thing. That makes sense as a mechanism. 2.5 inch abrasion on the abdomen, that's that group that ran across the abdomen. And then another group on the right side of the abdomen. And another group we didn't show you for modesty's sake, but there was a 1-inch group of abrasions neck to the vagina. And then another abrasion, a little more than 1/2 inch on the right arm. And on the back side of the right arm, there was a little more than 1/4 inch abrasion. And on the back of the, or on the right thigh, 3.5 inch group of abrasion. On the right knee, that individual abrasion, a little more than 1/2 inch. And I should say this one could be from falling down. Okay, so if you fall down, you skin your knee. It's in the right area. That could also be when she collapsed to the ground. Less than 1/4 inch on the left knee, 2 of those. And then on the left shin, there's a wound that I really can't describe any better than a defect. There's 1/10 of an inch hole in the skin, for lack of a better descriptor, but it's so small that I can't tell you exactly what kind of wound, probably blunt force. And then on the back, there was a 3.1 inch group of abrasions, and these also had some scarred borders, so this is not only fresh, there's some signs of healing within this group. So 2 separate types of wounds here.
When you say fresh, are you able to assign a time range to that?
I would say probably within hours of death. Again, the scars, the stuff that has heaped margins, those are healing. The stuff that's fresh doesn't have any of that. It doesn't have a scab on it. Scab is an indication of older.
So all of these injuries happened within about an hour of death. Is that what you're saying?
Within a couple of hours of death, I think that's fair.
We've moved to fresh internal now, is that right?
Yes, so now, we're still with fresh injuries, but now I've, for lack of a better way of saying it, I've removed the skin, I've dissected the skin away to look underneath the skin, because it's hard to see some of these injuries, particularly with dark skin. It's hard to see what's there. So unfortunately, one of the processes I have to do is dissect the skin away. to see what's there. And on the back of the scalp, you saw the photograph, that 1.5 inch area of bruising. And the temporalis muscle, that's the muscle right here in front of your ear that kind of fans out, and there's bleeding into that muscle. The right side of the chest has a 2 inch bruise. Left side has an 1.5 inch bruise. On the outside of the lung, we saw the photograph of that 1 inch bruise that was on the inside of the right upper lung. And surface bruise on the lung surface. Didn't see where that one came in, sorry.
Right pectoral, I think.
Here?
Yes.
Okay, so 2.5 inch group of bruising around the heart. So significant blunt force there. And the thing about that is that you could argue that I could have put that with critical injuries, because if you remember, I think it was last year, the NFL player that got hit in the chest and stood up and then collapsed to the ground. That's called commotio cordis. Fancy way of saying you took a blow to the heart at just the wrong moment in the electrical cycle, and it caused basically an electrical heart attack. So I could easily have put that there, but I think the liver injury in this case is probably more significant. But that's not to say this isn't significant. And over on the right side, the adrenal gland sits right underneath the liver. I mean, literally right against the liver and the right kidney. And there's a 2 inch bruise there. So that trauma, again, it's deep. It's on the front of the liver. You saw the laceration. It's also on the back of the liver. So this is a, for lack of a better way of saying it, full thickness injury of the body at that site. The pancreas is, if the liver sits here, the pancreas is right below that and runs from the liver over to the spleen. And the pancreas had a 2 inch bruise, again, right below. So not only is this front to back full thickness, it's now going over toward the other side. A large area was involved. The right, typo, that should be buttocks. There's a bruise there as well. A 1 inch bruise underneath the scale of the right knee. On the back of the outside of the right calf, a 1 inch bruise. 1 1/4 inch on the left upper back bruise. 3/4 inch behind the left elbow. 2 inch bruise on the inside of the right knee. And again, the blood in the abdomen, we've already talked about that. That's repetitive from the others, just so you're aware. Okay, and then I said there's stuff I just don't know. And I think you can just run through these, because I really don't know the upper inner lip, the lower lip. All of these are the same thing. There's discolorations there. I can't tell you definitively that these are all injuries. I can't tell you that they're not injuries. I don't know. And then there's old injuries externally. Again, I think, we can do these individually, or I think if you look at them, you'll see that there's a 1/2 inch scar, scab and scar, scar, all this on the chest, 2.5 inch scar. And you see, as I mentioned, what battered child syndrome is: multiple wounds, multiple locations, multiple stages of healing. I think that you can see just on that right side of the body so far, this clearly fits the bill. That clearly fits the definition. Now you're going to see the left side of the body, the same level of old wounds. Multiple wounds, multiple locations, multiple stages of healing. And the 2 rib fractures, right 5 in the back, left 7 on the side. And then the bleeding, there was also bleeding to the stomach area and a healing bruise at that location. So that probably has something to do with the bleeding around the heart. But I can't tell you specifically because it could be two separate events.
And by old, you just mean older than a few hours before death? Is that all you can say on that?
No, so the scars are obviously older, old enough for something to scar. But the scabs are fresher than scars, and there's a lot of stuff going on here. This is a lot of injuries. So again, perimortem is stuff that happened around the time of death. This is likely, a lot of this is animals, like the 2 1/4 inch area around the right eye. But as you go through this list, you'll see that there's a lot of stuff around the face and the head, which is one of the reasons that makes me think that it is likely animals. There's, in addition to around the right eye, there's an area on the bridge of the nose that's also looks like animals. And we now, just down here, are getting beyond the face and head area. So the collarbone, the axilla is the armpit. Then the area around the vagina, the right abdomen, the inguinal crease is right above the thigh. The brachium is the upper arm. And you can see the right forearm. The phalanx are the fingers, the right wrist, the palm. So again, lots of stuff that I think are animal. I can't tell you that they're actual injuries. I'm just telling you this is what I found. And again, more stuff. And this is, now we're getting to the legs and the back.
I went too far. Is there anything else you need to say on this slide or no?
Yeah, this is just more of the same. I'm going through very detailed. I think I have 11 pages of injuries. Pre-mortem, post-mortem, critical, fresh. I spent 11 pages to document all of that. And then to kind of put it into context, because that's what you do. An autopsy doesn't happen in a vacuum. A subject who's been injured isn't injured in a vacuum. So all of this stuff is important. So if we step back and look at what we spent the past hour going over, the critical stuff is here in the abdomen, the liver laceration, that 2.5, 3 inch laceration there, the 3.5 inch clot associated with that on the liver, the 4 ounces of blood in the belly, all of those fresh external injuries, all of the fresh internal injuries. I put up the uncertain because I don't know, and I don't want to tell you they aren't there, like I don't want to tell you that's for you to decide. I can't tell you they are or not. And you may reach the same conclusion I did. And then just to remind you of all the old injuries, or at least some of the old injuries, because there are actually too many, I think, to fit on the screen. This is important for the battered child syndrome component of why she died.
You indicated cause of death was multiple blunt force injuries, and you noted, we said earlier, malnutrition and battered child syndrome were other significant factors. Can you explain to the jury how malnutrition and battered child syndrome contributed to the death in this case?
Sure. So malnutrition affects the overall being of the person, the physiology, how your body heals, how your body reacts to an injury, your lack of muscular strength to withstand blows, the lack of muscular girth. If you, for example, take a blow to your chest, you have less tissue to protect yourself. So the malnutrition is important there, just like the battered child syndrome is important. If you've ever seen an abused animal, and you've seen the person that's abused that animal step into the room, you've seen the reaction. I've seen that. I have actual videotapes from prior cases I've worked of the same thing happening with children. And I'm a much younger child than Amari. Amari was 8. The child I've seen in the video is about a year. but they react when the abuser comes in. And if you've ever been scared or frightened, fight or flight response, what happens? Your heart rate goes up, your heart starts beating faster. Your blood pressure goes up, your blood is starting to pump harder. You're starting to breathe more because your body needs more oxygen. But if you're sustaining injuries, you're in pain. That pain increases all of those fight or flight responses. Actively during the process of her end, Amari is bleeding out of the injuries. She's also in fear because there's nothing to her head. She's conscious. There's no reason for her to be unconscious when all of these, or when the critical injuries are inflicted. So she's in fear. She's physiologically responding to that. So that's why each and every single one of those injuries, fresh and old, to me is physiologically important and why she died.
Thank you, Dr. Downs. That's all I have.
Thank you.
Do you need any of these slides, Rob?
I think the questions I can answer without the slides.
Let's go ahead and do the morning break. All right, ladies and gentlemen, we're going to take a 10-minute recess. All right, anything to take up outside the presence of the jury?
Not from the stage, Your Honor.
You need me, Chief?
No, ma'am, no, ma'am.
We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality we shout out loud. With justice here we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride. Justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. Place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. Every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. Watch us rise. We ignite the change, open eyes. Open like the shine. Together strong, we'll never fall. Justice is a right for all. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. Voices loud and hands up high. We'll break the chains and touch the sky. With every step we take in stride, justice by our side we ride. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place, fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. In the heart of every place. Fight for love and endless grace. No one left out in the cold. Our truths are brave, our stories told. We stand tall for truth you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the
I'm the big guy.
The bow tie is camouflage. All right, with the defendant now present, just a couple of housekeeping matters before we bring the jury back in. I guess the big question is, do you want to go ahead and release them so that they can, when we're done, have them go for lunch and then come back and do closings and everything after lunch?
Judge, I would prefer to release them and then do closings after lunch.
And what I was gonna ask Judge is, because I believe Dr. Downs is the state's last witness, that my cross is gonna be, limited, brief, that I assume what I would ask is the state rest at that point, and, I'll rest at that point thereafter. Do a motion for a directed verdict outside the presence of the jury. So sort of do it in reverse order, that I rest first, send the jury to lunch. We have our, motion for directed verdict hearing, and then whatever other charge conference we need to clean that up, come back, and then we can do closings. So I guess what I'm saying is, I'll rest on the record after the state rests, but reserve the, motion for directed verdict so that we don't have to bring them in and back out. That's all.
Any objection from the state?
Absolutely not, Judge, thank you.
And I've used up all my words that I said clearly.
Understood.
What do I got, doctor? You're a doctor. What do I have? Sinusitis? What do I have? The diagnosis of it?
You don't want him as your doctor.
No, because it's too late.
Well, my procedures are a little invasive.
I see, yes, sir.
Are we ready for the jury?
Yes, Judge.
Yes, so would that work?
I think that's great. Please be seated. All right, Mr. Greenwald, cross-examination.
Thank you, Judge. Good morning, Dr. Downs.
Good morning.
Hopefully you can hear me and understand me with my raspy voice. Do you want any water or anything?
I'm fine, thank you, sir, I appreciate it.
No problem. I just have some clarification questions for you, Dr. Downs. You did the autopsy on November the 24th, 2021.
That's correct.
Okay. And Amari, as far as we believe, her body was located, discovered the day before, right? November the 23rd, 2021?
Yes, sir. I did the autopsy about 11:30, and she was pronounced dead about 12, probably found maybe an hour before that, the day before.
Okay, so the day prior. Based upon your examination of her, can you put an approximate time frame on her death in relation to the 23rd of November of 21?
I would really be hesitant to do that for a lot of reasons. One is that she's in plastic bags, so that hinders decomposition. It's November, so the temperature's going to be important, hot, cold. She's in a wooded environment, so the sunlight coming and going, it would really take a lot more detail for me to be able to say when she died. In addition, I don't know if, because there's an interval, what the conditions were between when she died and when she was placed in this environment. That's not something I feel comfortable telling you a definitive answer to.
Okay, could it stretch from a couple of days to a week out, or you're hesitant to even go that far?
It would depend. If she didn't have any refrigeration, for instance, if she's in a cold refrigerated room, that would slow down decomposition. I would really need to know more about the weather, the environment. I can tell you this, if all else being equal, she didn't appear to have a lot of decompositional changes. Instead, what she had was animal depredation.
Because this was late November and the weather tends to be cooler.
Yes, sir.
In late November, okay. Well, let me ask you this way. In regards to the laceration of the liver, would that in and of itself have caused her death?
Not Amari's death, but if you took somebody in every other way, shape, and form like Amari and inflicted that liver injury to them, that person could die just from that liver injury, but that's not Amari. Amari had everything else going in that physiology we talked about with battered child syndrome.
So the lacerated liver, if untreated, that would not in and of itself have caused her death if the injury was left untreated for a period of time?
Again, you can't isolate in Amari's case one thing because it didn't happen that way. You have somebody who has this background who then has an injury inflicted on her. If you take somebody else who's not Amari, but just give them that liver injury, then that person could die with an untreated liver injury like that.
What would be the time frame for a person to die from the lacerated liver?
Again, exactly the circumstances, like Amari, it's hard to say. If it's not her, but somebody with just that liver injury, I'm not a clinician, that is, I don't treat people. I can tell you that I would think a couple of hours would be probably pushing it. She had 120 milliliters, which is 4 ounces of blood in her belly. Her total blood volume for a kid of her weight, now she probably has less because of her malnutrition, but they would have 1.8 liters 40% say, and hers may have started at 30% because she's malnourished.
The, in your autopsy, I think you noted that she had a right rib fracture. Would that have occurred prior to her death, after her death? Do you know one way or the other?
Yes, sir. Both of the rib fractures, both the right and the left, were older. That's part of the basis of the battered child syndrome.
So it was both right and left?
That's correct. The left was fresher, but still old.
Can you put a time frame?
It's really, really hard to do. I would say with the fracture callus, which is when you get a fracture, the two ends of the bone come together and you get a lump where those two bones come together. On the left, that lump, you could see where the fracture line was. So that's probably weeks. And then the other side, I didn't see that pattern, so that's probably months, or it could be much older.
Understood. The blood work that was done, that all came back negative for drugs, if I understood, on page 20 of your report.
That's correct. So we send our samples out to the GBI lab, and in this case, we also sent out for chemistry to a different lab. But the blood work for drugs was all negative, and the other lab didn't find any drugs either.
Okay. And needless to say, this was not a case where you found any type of gunshot wounds, stab wounds, anything of that nature, correct?
No, sir. Exclusive of what we talked about, the multiple blunt force injuries and the older healed and healing injuries, the battered child syndrome and the malnutrition. This was an otherwise healthy young girl that had no additional trauma.
And we've used a couple of terms here when the state was asking you some questions. Scabs. What specifically were we talking about when we're talking about a scab versus a scar?
So a scar is actually fibrous tissue that mends together, it meshes together. So you've got, it's almost like weaving it back together with tissue that binds the edges of the wound together and the skin becomes intact. A scab is a layer of dead cells, pus, dried debris that forms over the surface of a wound. That's during the process of healing. So while that scab is there, you're getting healing underneath the skin, but the skin is not fully woven back together. So that's the difference, is the scar means this is old. The scab means we're still working on it. It's still in the process of healing.
And I realize every person, every human being is different from the next one, but generally speaking, how long does it take for a scab to occur?
It can happen very quickly when the wound is small and exposed to air. The blood's going to clot on the surface and can heal. I mean, I would say common experience would be the best way to answer that. You've seen those, but the thing is, you also have deeper wounds that heal more slowly because they are deeper and it takes more time. There are some wounds that don't get stitched back together. You stitch an open wound to bring the edges together to allow that fibrosis to happen underneath. The scab forms on top. Those heal very quickly, so those scabs don't last a long time. Versus an open wound, it takes longer, and I just can't give you a precise timeline.
Would it potentially be within a couple of days?
Depending on the type of wound. A deeper wound is not going to be a couple of days. It's going to be longer.
Okay, and again, knowing every person is different, how about in regards to a scar? Is there a particular time frame for a scar to
Where I
occur?
can tell you that it will be scarred, I don't think you can really do that. If you've got scabs, kids pick at scabs. That then kind of sets the clock back a little bit. Also, with her malnutrition, she's going to heal more slowly. So I really can't give you, I wish I could tell you, it's going to take 2 weeks. It's going to take 4 weeks. That wouldn't be accurate.
The malnutrition affects someone's skin,
It affects the entire body.
but specifically in regards to the skin, what's the effect of malnutrition on a person's skin?
Well, you're going to lose subcutaneous fat, which means the skin is going to be thinner, and you lose the immune response becomes impaired, so the white blood cells that come in to help with repair are going to not work as well.
Would it be more susceptible to bruising?
I would say probably it would be more susceptible to bruising because you wouldn't have the structural integrity, you wouldn't have the subcutaneous fat. So yeah, I would say probably more susceptible to bruising. And also depending on what's missing, for instance, vitamin C, scurvy, that condition, and others like vitamin K, clotting factors. Yeah, I would say probably more prone to bruising.
You also had mentioned in the direct, use the word fresh in regards to fresh injury or in the context of wounds and so forth. Can you elaborate a little bit when you use the word fresh in that context, what you're referring to?
Not to be smart in the answer, but it means not old. So I'll try to explain that a little better. Fresh would be anywhere from it just happened out to where the white blood cells, specifically a type of cell called a PMN, a neutrophil, that's the same cell, those come in by a couple of hours. I expect to see those specific cells. Out to 2 to 3 days, I see different types of inflammatory cells, and I see red blood cells breaking down. So when I say fresh, it's somewhere from that just happened out to where I get the white blood cells, the neutrophils, and some other reactive changes, but I'm not seeing that second wave of inflammation coming in. So we're not talking 2 days.
2 days from the time, obviously, you're examining.
No, sir. The process, the clock stops when you die. So what I'm saying is, whenever these events, when these fresh injuries happened, was within that time frame of when she actually passed. So the clock stops when she passes.
So within 2 to 3 days of her death, of her passing.
Correct.
And when you mentioned in your report, Dr. Downs, the manner of death being homicide, that doesn't equate to murder, that just equates to death at the hands of another?
That's correct. Murder is a legal term. We specifically don't use that word. I am not an attorney, don't pretend to be one, don't know much about the law at all. I know enough to ask a lawyer.
Okay. So that in and of itself just means death, when you put homicide, death at the hands of another.
Right, literally the word itself is homis, H-O-M-I-S, side, to kill. Homis is human or man. One man or one person kills another person. That's all it means.
And obviously, when you got involved in the case, you can't make a determination, speculate, do anything of that nature in regards of who or whom may have inflicted those injuries that you noted, correct?
No, sir, I don't speculate, and I do not identify perpetrators. That's not my job. My job is to tell you, this is what I saw. This is what happened to Amari. These are all the conditions that are there. And it's up to investigators to take it from there.
Thank you, sir.
Thank you.
No redirect, Your Honor.
May the witness be excused.
Yes, Your Honor.
No objection.
All right, thank you, Dr. Downs, you're excused.
Thank you, Judge.
Take care. All right, any other evidence from the state?
Your Honor, at this time, the state would rest.
The state has rested. Mr. Greenwald, any evidence from the defense?
Your Honor, at this time, the defense would rest on the presumption of innocence in her favor, Your Honor.
All right, thank you, sir. All right, ladies and gentlemen of the jury, it's, wow, it's early, it's 11:10, so we're gonna break early for lunch today. and come back at 12:30 be sufficient?
It would, Judge.
Want you guys to be back in jury assembly at 12:30. Remember, no talking, no watching, no reading, no listening about this case. All right, Mr. Greenwald.
Judge, with the jury out, or on behalf of my client, I will at this time, make motion for directed verdict of acquittal, in regards to counts 1 through 18 of the indictment. She's not charged in count 20, and good faith, Judge, I don't believe I can make that argument in regards to counts 19 and 21. However, in regards to counts 1 through 18, I would ask the court to direct a verdict of acquittal, in that our position is that the weight and sufficiency of the evidence introduced by the state up to this point are not sufficient as a matter of law for the jury to return the verdict of guilty. Specifically in regards to the murder, the malice murder, the felony murder charges, Judge, there has been no direct or even circumstantial evidence I would submit to the court that showed, at least to this point, that Ms. Owens aided, abetted, assisted Ms. Hall in the death of Amari. Further, I would submit to the court there's no direct and even circumstantial evidence that Ms. Owens directly caused the death of Amari. And so for those reasons, Judge, we would respectfully ask the court to direct a verdict of acquittal.
Thank you, sir. Ms. Nazim.
Your Honor, the state would strongly disagree with that, given the nature of the evidence that's come out during this trial, not only the videos. I think the videos would be more than sufficient to allow the jury to make a decision as to whether or not this defendant was involved directly or indirectly with the cruelty to children charges. As far as the murder charges are concerned, Judge, there is, in the state's opinion, enough evidence, sufficient evidence for the jury to consider all the injuries that were inflicted upon the victim in this case, and take that under the guise of party to a crime as a participation of this defendant in inflicting those injuries, which ultimately led to the death of the victim. And therefore, the state would ask that that you deny defense counsel's motion and allow the jury to have this case to make their ultimate determination.
All right, thank you, ma'am. All right, Mr. Greenwald, taking into consideration the evidence that's been presented throughout the trial, the court is going to deny your motion for a directed verdict. There is sufficient evidence for charges 1 through 18 to go to the jury.
Yes, sir.
Thank you.
I'll just accept for the record.
Your exception is noted. All right, I have prepared new copies. Tracy's that said about the killing trees, of the proposed request for charges.
Thank you, Rob.
One for you and two for the state.
I guess hands in.
right, so can we start first on page 5 with witness impeached?
I believe we're holding that in case the defendant testifies, since she chose not to testify, I believe we don't need that charge.
It was way too fast for my brain. Why?
We left that charge in the event the defendant chose to testify and she was impeached on cross. That didn't happen. I don't remember there being any other impeachment of any other witnesses on trial, so I would say that charge is not necessary.
I would agree, Judge.
All right, 1.3, 1.45, witness impeached is withdrawn. So also on page 5, 1.32.10, defendant's choice not to testify.
Just the second paragraph, I think would apply, Judge.
Agreed. Going to page 7, 1.32.50, conditions precedent to consideration of a statement. The last sentence with the parentheses.
Given that we removed the previous impeachment charge, I would say we can remove this language as well, Your Honor.
I think all of it does, I mean, because it says credibility of the witness, so she never testified, so I
Cor-
think that
cor-
was,
So, correct, so the entire parenthetical and impeachment should be removed, correct?
Yes, ma'am.
Can we go back for a second, going back to page 5, 1.32.16, statement of the defendant. We had previously left that in.
I believe at this juncture, to avoid having to define which part of the statement was in custody and which part was not, we should leave all the parentheticals in and then run for caution. Right?
yeah, I didn't have a strong preference one way or the other.
Any objection to that, Mr. Greenwald?
No, Your Honor.
All right, we'll leave that in. Voluntariness defined, burden of proof as to voluntariness and constitutional rights.
Yes, sir.
And I think the only other thing remaining, page 12. .20.21, aggravated assault. The state requested that we modify the language so that it tracks that of the statute as opposed to the pattern. And it says for an aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with an object, device, or instrument when used offensively against a person, should be a person, is likely to or actually does result in serious bodily injury. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. An object, device, or instrument when used offensively against a person that is likely to or actually does result in serious bodily injury is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone.
Your page is good with the language that was modified there in 2.20.21, and because of those modifications and the fact that the last paragraph there defines what the object we use offensively means, I think we don't need 2.20.23.1 anymore. The section right below that. Because that talks about deciding whether an object is an offensive weapon. We took out the language of offensive weapon, and the last paragraph above that defines how an object is used offensively, so I don't think we need a second.
So you're withdrawing S 34 section?
Yes, sir. We would say we withdraw S 34, given the change in language to that so.
I think we should give it, especially if you want to include, although the hands and feet are not deadly weapons per se, they may or may not be deadly weapons depending upon the manner in which they are used and the circumstances of the case. Whether hands or feet constitute weapons in this case are factors solely for your determination. This defines what an offensive weapon is, an object, device, or instrument, the nature and extent of the injury inflicted, the manner in which an object, device, or instrument was used, and any other circumstance. I think all three go together.
Okay, I don't think it's gonna hurt anything to leave it in, I just didn't think it was necessary, so we can leave it, that's fine.
Mr. Greenwald?
Yeah, I have no problem leaving it, Judge.
And so then we have the state's request to charge on hands and feet as weapons. It's a non-pattern, and it's from the case of Green versus the state, 291 Georgia, 287, it's a 2012 case. And then Sandstrom, Sandstrom versus Montana, 442 U.S. 510, 1979 case. Any objection to that instruction, Mr. Greenwald?
The only request I would have, Judge, is the last sentence of page 12, where it says whether hands and feet constitute weapons in this case. I would ask that where it says whether hands and feet, comma, if used, comma, constitute weapons in this case, or factors solely for your determination. Otherwise, it sounds like court is quasi-commenting on the evidence in the case. And I think that's the province of the jury, to determine first if hands and feet were used. Does that make sense?
I understand what you're saying, yes, sir. What says the state?
That's fine with us, Judge.
Whether hands and feet, if used, comma, if used, constitute weapons in this case.
Yes, Your Honor.
Okay, so bottom of page 14, under sympathy, I think somebody had said, Mr. Greenwald, maybe it said to remove remote resident of the state.
Oh, I said that.
Mr. Brown, remove remote. I think if you just put local residents, it doesn't make sense. So I think you either leave it all in or take it all out. And I think
Leave it all
leaving
in.
it.
No objection.
I don't think I had anything else.
Everything else appears correct to the state, Your Honor.
Yes, sir.
Okay. I'll kill some more trees and get some clean copies.
Judge, can we just go on the record one last time after further conferring with my client, Ms. Owens, it is again your decision that you do not want to testify, so you understand the evidence is closed in the case.
So just want to make sure, because that was a double sentence. You understand it's your right to testify,
Yes, I understand.
and you have chosen not to testify,
Yes, ma'am.
and you understand the evidence in this case is now closed.
Yes, ma'am.
Or it will be when we have the jury come back in and I tell. Okay. All right, y'all enjoy lunch.
Thank you, Judge.
What time did I tell them?
12:30.
In other words, don't kill more trees for me.
We get you the file.
That's fine.
And they'll-
I'll wait on it to me. You can email it to me. I'm gonna look at this through to. green wall comes up, there's some things that I would like to talk to you about. Little roadmap of the things to consider as you deliberate, as you process the information and the evidence that you have received, put it together with the law. But as you do, please remember, sometimes the truth is right before your eyes. Sometimes it's just not that hard. And this case is one such case. This case involves two people. They're both charged in this indictment, and Brittany Hall, she'll have her day. She'll have her jury, and we'll be ready. But today is this defendant's day, and she is charged as a party to a crime. The judge will tell you that this concept of a party to a crime, it is incredibly important within our legal system because it holds people accountable for their part in any crime. Each of you have indicated that you agree that it can take more than one person to commit a crime. That people can be held accountable for the roles that they play in a crime. That is what's called a party to a crime. You can either directly commit the crime, as you saw this defendant do in numerous videos that you have seen throughout this week, or you can intentionally help in the commission of that crime. And when I come back and we have an opportunity to look at that again, and you can hear the two voices that are talking in some of those videos and understand the context in which both of these people were living together, caring for these children, then you will see they acted together. And the reason that this concept is so important is because, think about it this way. I like to help juries understand this concept in a very simplistic way. Think about a bomb maker. Think about someone who provides a weapon. You have someone who gives an explosive device. You have someone who gives wires for that device. You have a third person who puts it all together, and a fourth person who carries it into the middle of a crowded street and detonates that bomb. Well, guess what? Every single person responsible for the completion of that crime is a party to a crime, and either guilty because they did it or because in some way they helped in the commission of that crime. This defendant helped beat the living life out of Amari. She is a party to a crime in every single one of that indictment because she had her hands all over that girl. Just like someone who provides a weapon. Here's two of the exact same guns. Please go over there and shoot up that school. You go over there and you start shooting the school, someone dies and they say, well, I don't know which gun it was, so you can't actually, it's not me, it's got to be the other guy. No, party to a crime holds people accountable for the roles that they play in each of the crimes. And she is responsible for the role that she played. Keep in mind the method that each defendant used for abusing these children. The slapping on the back of the head, the stomping, the blindfolding, the laying on the ground. They did this together. Their method was together. So it doesn't matter who delivered the fatal blow. Because, ladies and gentlemen, there was not one fatal blow. Every single blow was fatal to Amari. Every single one. You saw that. You heard Dr. Downs say that. So remember, because of the battered child syndrome that he explained, that we'll talk about again a little later, every single blow mattered. It doesn't matter. Just like it doesn't matter who pulled the trigger, it doesn't matter who delivered the fatal blow. It could be Brittany, it could be Celeste. It makes no difference. They are both guilty, and today is her day. Because if they both hadn't done it together, if she hadn't done her part, Amari wouldn't have been beaten to death. Doesn't matter who the main caregiver is. Doesn't matter who the biological mother is. None of that matters. This defendant, in her interview with Detective Sorensen, said, we're both the parents. I'm dad. That's what they call me. We never leave the kids alone. We're homebodies. We're always home together. what we have to prove. We have to prove all of these charges, all the elements of these charges to you beyond a reasonable doubt. What does that mean? Everybody's heard that on TV. Everybody's heard that in the news, on the radio. It doesn't mean beyond all doubt. It does not mean beyond mathematical certainty, because remember, sometimes the truth is right before in your eyes. Sometimes it's not that clouded. Reasonable doubt is that the judge will instruct you, the doubt of a fair-minded juror, honestly seeking the truth about what happened to Amari. This defendant is equally responsible for the role that she played in the death of Amari. Your job is not to look for doubt. Your job is to use your common sense, because sometimes the truth is right before your eyes. You will have evidence to consider. I'm giving you just a roadmap, the ingredients that you will need to complete your verdict at the end. You have heard testimony from numerous witnesses, law enforcement, medical. Zaire, Mrs. Wright. Numerous witnesses who came in and verbally told you about the things that happened, about the things that they saw. You've seen multiple exhibits in the form of photographs. You've seen videos. You've heard about stipulations that we have agreed to. That's the evidence. And evidence can come in two different forms. It can come in physical evidence, like what you have essentially seen on video, the beatings that occurred. You can see the photographs of the physical state of little Amari. But there's also something called circumstantial evidence. We've seen her on video directly slap Amari. We've seen her directly beat those children. The law allows you to use by inference what is most likely, what is most reasonable that happened. And the most reasonable thing that happened is that this woman who is living in the home with Amari as her caregiver, along with Brittany, who was beating all the children in a similar manner, also participated in the beatings that went on for an extensive period of time to Amari. You don't have to see it to know what happened. It's just like you wake up in the morning and you thought you heard some rain all night long, and you're like, oh, I wonder if it rained. And you go outside and the sky is clear and blue, but you look on the ground and there's water and the grass is wet and there's water on your car. Well, it's pretty darn reasonable that it rained last night, even though you didn't see it. That's circumstantial evidence, and they both hold equal weight. Testimony is equally weighed as circumstantial evidence. And then you're going to look at the credibility of the witnesses who came in. You know, who has something to gain, who has something to lose. Going to see little Zaire. What did she have to gain coming in here? And we'll talk about that. I want to explain the most important charges, because I think as we go through this indictment that you will have with you when you go back, there's a lot of charges on here. Because she did a lot of things to these children. So there's a lot of charges. But the most serious of which start at the top with malice murder. Malice murder will be defined when a person commits the offense of malice murder when they unlawfully and with malice aforethought cause the death of another human being. Now, I know it's a lot of legal words and things that may not really be used in our everyday language, but it's really very simplistic when you think about it. Malice murder is when there is malice or a malicious act that's occurring. Malice is defined where all the circumstances of the killing show what's called an abandoned and malignant heart. Okay, this is, again, a lot of legal words to say that you have essentially the circumstances in which you kill this child. Those circumstances are hateful and wicked and savage and spiteful. They are so malicious in nature showed you through the photographs and showed you through the autopsy, her broken little body that was so beat, that is malicious in nature, done together. There's no premeditation that is required. This defendant didn't have to sit there and plan Amari's murder. She didn't have to do that because malice, that malicious intent, can be formed in just a moment, and in an instant, even a fatal wound can be inflicted. Again, what this means is, it doesn't have to be one fatal wound. We know that. That's what Dr. Downs has testified. But the malicious nature in which those wounds were actually perpetrated and in which the death occurred, that is malicious. That's malice murder, and that resulted in her death. Causing multiple blunt force injuries to her little body means that she acted with malice. That's malice murder. Again, I just want to give you a roadmap, and we can talk about how all the evidence fits in. And the other charge that you will see here, it's a little different, but it's still murder. And please remember that you can find this defendant guilty of every single one of these charges, all the different murders, because there were so many ways in which Amari was killed. You can find her guilty of every single one of these murder charges. And felony murder is when someone is involved in the commission of a felony and you cause the death of another person. You don't need malice. But in this case, there's definitely malice. And there's definitely evidence that this defendant was engaged in 3 different felonies. Cruelty to children in the first degree. When she's beating Amari, when she's slapping Amari, that's an indication of all the other things that were happening in that hellhole of an apartment studio, Hometown Studios, Congress Hotel. That was living hell based on the body of Amari. And we'll talk about each of these charges. She is charged in 3 different counts of felony murder for committing 3 different felonies. Cruelty to children in the first degree, causing physical excessive mental pain to Amari. Again, we'll talk about that when I come back. I want to give you the roadmap of what you're looking at. 3 different felonies that she participated in, committed directly, or helped commit. Cruelty to children in the first degree, aggravated assault, aggravated battery. Each one of those is the felony that resulted in the death of Amari. That's felony murder. 3 different felonies, 3 different felony murder charges, and the malice murder charge because it was so malicious and vicious the way that child was beaten. It took 2 people to kill Amari. Like I said to you many days ago, it took 2 people to kill her, 2 people to cover up her murder, and 1 person who I think the evidence is clearly established was the one who actually dumped her like trash. And like I said, Brittany will have her day, but today, it's this defendant's day. Ladies and gentlemen, I am going to sit down. Mr. Greenwald will have an opportunity to talk to you. It's important that you understand the concepts of the law. The judge will also give you. Please remember, truth is right before your eyes. And I'll be back.
Mr. Greenwald.
Thank you, Judge. Good afternoon, ladies and gentlemen. Hopefully you can hear me okay. Good news and bad news. The bad news is each side gets up to 2 hours to talk to you all. The good news is I don't plan on taking 2 hours to convey, from our perspective, what should be conveyed to you all. Now, we're blessed here in Gwinnett County. Ms. Nizam, Mr. Brown, excellent, fine prosecutors. Should be very proud to have them working in the district attorney's office. They do a great job. Judge Duncan does a great job every time I'm before her. She is sort of the referee in this case. We rise, if you want to know why the lawyers rise, when you all come in the courtroom, it's a sign of respect. Because you all are the actual judges in this case. You are the judges of the facts as you find them to be. After I sit down and Ms. Nizam gets to come back up and make a concluding argument, Judge Duncan will tell you what the law is, define legal terms for you, and it's called jury instructions, jury charge. And then after the judge tells you what the law is, you'll disappear back through that door and you'll get a chance to deliberate and return a verdict that, in your opinion, speaks the truth in this case. It doesn't matter. It's a hard thing for a lawyer to say, but it doesn't matter what the lawyers think. It doesn't matter what the lawyers believe. What matters is the evidence in this case. And what matters is what you all ultimately believe and ultimately decide. Now, as I told you in opening a couple of days ago, I'm not a moron. I'm not an idiot. I get the heartstrings of this case. I've got 3 kids at home. My late dad was a New York police detective for 30 years. So I get it. It's tough. It is awful that all of us had to meet under these circumstances. It's a tragedy. Can't shirk it, can't put it aside. It's awful. But one of the charges that Judge Duncan is going to tell you is sympathy has no place in your verdict. All of you are sitting in those comfortable chairs rather than out there on the benches because you all told us in jury selection that you were impartial. You heard it over and over again. Were you leaning towards one side versus the other, or were you right down the middle? All of you said you were right down the middle. That's why you're sitting there now. And so when you go back to deliberate, and yeah, it's an awful case. It's a horrible case. It's not a shoplifting, it's not drugs, it's not DUI. I get that. But you're to base your verdict on the evidence, or the lack thereof, not on emotion. And so, Ms. Nizam, in her first closing argument, she used the phrase, and she's an excellent lawyer, I'm not knocking her. She used the phrase, little Amari. Amari's broken little body. Those are all emotional terms. Those all tug at the heartstrings. And the case itself tugs at your heartstrings. I get that. But at the end of the day, ladies and gentlemen, after I sit down, Ms. Nizam sits down, Judge Duncan tells you what the law is, you are to base your verdict in all these counts not on the heartstrings, not on emotion, not on sympathy. You are to base your verdict on the evidence or the lack thereof. Plain and simple. No matter what phrases you hear, no matter the images that are posed to you, whatever words are used, that's what you're to base your verdict on. The evidence or the lack thereof. So start off with this concept. There is no direct evidence, and there's two types of evidence: direct evidence and circumstantial evidence. So let's talk about what's direct evidence. Direct evidence is a witness comes in, says, I saw Celeste kill Amari. Saw her hands around her neck, saw her take a hammer and hit her. That would have been direct evidence. Somebody actually saw it. You don't have that in this case. Yeah, you saw the videos up on the screen of what was going on in the Congress Hotel. That was in July of 2021. That was not November of 2021. You saw no videos from the room at Hometown from November. So those videos that were played with Ms. Hall in some and Ms. Owens purportedly in the other were from July of 2021. So first off, in regards to malice murder, felony murder, the other two counts of felony murder, ag assault, ag battery, and you'll have the indictment out with you. There's no direct evidence that Ms. Owens, and you may hear her referred to as a defendant, well, she's Celeste Owens. There's no direct evidence she killed Amari. That's the starting point. Obviously, they're sitting at that table representing the state of Georgia, prosecuting the case, so that's their view of the evidence. But the evidence in and of itself, there is no direct evidence that she killed Amari. So you get to circumstantial evidence. And Ms. Nizam gave a very good description of what is circumstantial evidence. You go to bed, you're in your bed at night, and you hear droplets coming down on the roof, lightning, thunder. You believe it's raining. You wake up in the morning, go outside, the sun is out, the pavement is dry, the grass somewhat wet. Well, circumstantial evidence, it might be that it was raining the night before. But pavement being dry, it could also be asserted that that's morning dew. The sun is out, there's no puddles on the ground, yet the grass is somewhat wet. That is circumstantial evidence, because you didn't actually see what caused the ground to be wet after the sun came up the next morning. So that's the two types of evidence: direct evidence or circumstantial evidence. There's no direct evidence she killed Amari. I would submit to you all there's also no circumstantial evidence that Celeste Owens killed Amari. Now, you got the videos, you got the photos, but that doesn't prove what took place in November. Now, I'm also not an idiot and not a moron standing up here before you all. I'm not telling you you have to like Celeste Owens. I'm not telling you you have to appreciate her, respect her, like her. I'm not telling you that at all. But this case is not about who you like, who you don't like, who you respect, or who you don't respect. This case is about the evidence. When the state brings these charges, I don't care if it's 1, 2, or 22, they do have the burden of proof by evidence, beyond a reasonable doubt, that the person or persons, and in this case they've charged 2 people, Mom, Brittany, and I'm glad to hear she'll have her day in court, probably sometime in the new year, and my client, Ms. Owens. She's the one who's been on trial this week. So the state has the burden of proving to you all beyond a reasonable doubt that she is guilty of these crimes. Not that she's a bad person. Not that you should hate her, dislike her. The burden of proof, this is a criminal case, the burden of proof is by evidence to convince you all that she's guilty of all of these charges by direct or circumstantial evidence. They further, when you have the indictment out with you, you will see in each count, other than count 21, in each count, and I think count 20 deals with Brittany lying to the police, saying her daughter went missing. So counts 1 through 19, you will have, and you'll see the way it's indicted. And indicted just means charged. Fancy legal word for charged. You'll see that they're indicted individually as well as parties to the crime. What does that mean? That means the state is trying to have it both ways in the indictment. You'll actually see those words in the indictment, individually and as parties. The way it says, just to give you an example, in regards to count 1, it says, grand jurors charge and accuse Brittany Nicole Hall and Celeste Alexandria Owens individually and as parties concerned in the commission of a crime with the offense of malice murder. And it goes on that way for the next 18 counts. Individually, that they each individually killed Amari. And or parties together, working together by assisting each other, helping each other, committing these crimes. Well, which is it? Doesn't matter in regards to the evidence, because the evidence, whether direct, is not there, and whether circumstantial is not there. Not only that Celeste did not individually kill Amari with malice or without, but the evidence is simply not there that she assisted, helped, participated with Brittany in killing Amari. That's a tragedy. It absolutely is a tragedy. We should not be here, but we are. And since we are, when you go back out there after listening to Ms. Nizam's, I'm sure it'll be a great closing, and the instructions from Judge Duncan, when you go back out there to deliberate, this is not whether she's a good person, whether she's a nice person. This is whether or not the state, by evidence, has proven her guilt, either as individual or as a party to the crime in killing Amari. Party to a crime in basic terms means doing something, helping, assisting, participating. And in going over all the evidence, the videos, I just heard Ms. Nizam say something about 2 voices on those videos. It's not a crime to talk. It's not a crime to speak. Party to the crime means doing something to help the person commit the crime. Classic example is the liquor store robbery, where one person's the driver. They drive up to the liquor store, the gunman gets out of the car, goes into the liquor store, holds it up, gets the cash, comes back out, gets back in the car, and the getaway driver drives them both away. That's a party to a crime. The getaway driver, aware of what his co-defendant, armed robber, is doing, is the getaway driver. That's a party to the crime. Ask yourselves, in regards to the evidence in this case. What specifically did Celeste Owens do to help, assist, participate with Brittany Hall in killing Amari? What did she do? We don't even know, evidence-wise, ladies and gentlemen, the day Amari died. More importantly, we don't even know, evidence-wise, I don't care what lawyers say, evidence-wise, where Amari died. You don't even have any evidence of that in this case. So they want to say that Celeste, individually or as a party to the crime with Brittany, killed Amari, helped Brittany, assisted Brittany in killing Amari. Let's start off with, where was she killed? We don't know. We have no evidence of that whatsoever. And so from an evidence standpoint, I submit to you all, there is no evidence, not opinion, not talk, but evidence of what Celeste Owens actually did to help, assist, participate in Amari's death, Amari's killing. You don't have that. State has their theory, of course, and that's why we're here with these charges. But bringing charges does not mean somebody is guilty. The videos from July, yeah, horrific. Absolutely. But it's not evidence of what took place purportedly in November. It's not evidence that Celeste Owens knowingly assisted or participated in November in killing Amari. But they're hanging their hat, they're banking on what took place via video in July. It was Brittany who was Amari's primary caregiver. It's not a co-parenting relationship. We heard that from grandmother, Ms. Wright, that she and Brittany would co-parent all three children. And in that house, in that motel room, when the police showed up, who was giving the majority of the info? Height, weight, autism, medications to the police about Amari. It was not Ms. Owens, it was Brittany Hall, the mom. So she was the primary caregiver for Amari. I submit to you all that fact is uncontroverted. You heard from Zaire. God bless her. 9, 10 years of age, having to come into a courtroom in front of a group of strangers. Thankfully, she had a good rapport with Mr. Brown, with Brian. And thankfully, he told her that a nice man was going to be asking her some questions after he sat down. And I appreciate him telling her that. And I submit to you, she's a child doing the best she could. What's important, though, that I ask you to remember is Zaire, she didn't remember her mom's name. Okay. And she's up there doing the best she can. But she told you all, Mommy never hit me. Brittany never hit her. That's just not true. Ms. Wright, God bless her, Grandma, she was unaware that her daughter was using corporal punishment, hitting, smacking, kicking, stomping on her own children, Ms. Wright's grandchildren. But it's just not credible, not believable for Zaire to tell you all that Mommy never hit her, because that's not true. She also testified, and remember Judge Duncan swearing every witness in to tell the truth. I'm not knocking Zaire, but these are factors that you all have to take into consideration in deciding this case. Zaire testified she never slept in a bed. may seem like an innocuous response to something, but it's important. Why? Because for almost 3 months, from September through November of 2021, they slept in that second bed, in that room there at the hometown suites. When police came in that motel room to talk to Brittany and Celeste, what did they say? 2 other kids, who would include Zaire, were asleep in the bed. That's important because Zaire told you all she never slept in a bed. That's just not true. She told the police when Mr. Brown sat down and I got to ask her some questions, she had seen her interview and it refreshed her recollection when she talked to police 3 years ago. And I asked her, you remember telling the police that it was a man who took Amari by the neck and put her in a dark room? She said yes. She remembered that because that's what she told the police, that a man took her sister by the neck and put her in a dark room. She said also to the police, Amari had toilet paper in her mouth, and the next morning she wouldn't wake up. That's what she remembered from November of 2021. But none of that, ladies and gentlemen, from an evidence standpoint, shows Celeste Owens killing, murdering with malice or without Amari. None of that does. Ms. Wright was unaware of Amari's autism and was unaware of her medications. And I applaud Ms. Wright for being a great grandmother. I mean, she took care of these kids as Brittany came in and out of her life. Would have one child, go back to the nest, leave, have another child, go back to the nest, leave, and have another child. And God bless Ms. Wright for stepping into the breach time and time again in an incredibly painful situation. But none of that shines any evidence on Celeste Owens being a killer. I'm going to leave the cruelty to children counts. If you can square away and figure out the tattoos on the legs, no tattoos on the legs, who's doing what to whom back in July of 2021, I will leave that up to you all to decide from an evidence standpoint. But in regards to counts 1 through 8, the murder, malice murder, felony murder, battery for the lacerated liver, aggravated assault on Amari with an unknown object, please ask yourselves, no matter what I say, no matter what Ms. Nizam says, evidence-wise, where is the evidence to prove beyond a reasonable doubt that Celeste Owens did those things? It is not there. You'll have the verdict form out with you. That will go out with items of evidence. The verdict form lists all the counts. And you are to make an independent decision as to each count. Whatever your verdict is, you take count 1, count 2, count 3, and so forth. And let me go over, ladies and gentlemen, a little bit about what I expect Judge Duncan to tell you is the law in this case. Judge Duncan, I expect, will tell you that the defendant, Celeste Owens, is presumed innocent. So when we started the trial, it really wasn't leaning this way, it was leaning this way. Because Judge Duncan will tell you that the presumption of innocence surrounds and protects Celeste, and that presumption remains with her, innocence, until it is overcome by the state with, not opinion, you'll hear the word with evidence that is sufficient to convince you all beyond a reasonable doubt that she is guilty, and that the state has the burden of proving each and every element of each crime charge beyond a reasonable doubt. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. That's what a reasonable doubt is. Judge Duncan will tell you that the burden of proof rests upon the state to prove it beyond a reasonable doubt. She will tell you there is no burden whatsoever on us. We don't have to do anything. I could have sat here all trial, not asked one question, not done anything. Didn't have to make an opening statement, didn't have to make a closing statement, because there is no burden whatsoever on the defense to do anything. Still America, 2024, we don't have to do anything. But I did ask questions. Judge Duncan will also tell you that if the state, the prosecution, fails to prove Celeste Owens' guilt beyond a reasonable doubt, it would be your, and this is a key word you will hear when the judge tells you what the jury instructions are, it would be your duty to acquit her, find her not guilty, if they fail to prove her guilt beyond a reasonable doubt. You will hear that grave suspicion, mere conjecture, suspicion, maybe, could be, possibly, she's guilty, are not sufficient, aren't enough to find her guilty. Suspicion, conjecture, is not what the law requires. Yeah, the law doesn't require 100% mathematical certainty. That's absolutely correct. But the law does require proof beyond a reasonable doubt. And suspicion and conjecture, speculation, are not sufficient for you all to find her guilty. Judge Duncan will tell you that Celeste was under no duty, under no burden to testify. She didn't have to get up here and say anything. Because just like I didn't have to do anything, or say anything, or ask any questions, there is no burden on Celeste whatsoever to have to testify. And that you cannot, when you go back and deliberate and go over the evidence and the judge's instructions that you hear from her, you cannot use that in your deliberations, the fact that Celeste Owens did not choose to testify. Cannot at all base your verdict upon that. Judge Duncan, ladies and gentlemen, will define for you what parties to a crime is, because when you have the indictment and you look at it, you will see it says individually and as parties to the various allegations. And a party to a crime is a person is a party to a crime only if, and you will hear Judge Duncan tell you that, only if that person, in this case, Celeste Owens, only if she directly commits the crime or intentionally helps in the commission of the crime. That's it. To be a party to a crime, you either do it directly or you help someone participate with that person intentionally in committing the crime. You don't have that in this case, ladies and gentlemen. There is no evidence for either of those, that she directly killed Amari or intentionally helped Brittany kill Amari. Knowledge is an important aspect of party to a crime. And the judge will tell you, if you find from the evidence that the defendant, again, Celeste Owens, did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense or offenses. You're going to hear those words again, those two words. It would be your duty to acquit the defendant, Celeste Owens. Find her not guilty. Judge Duncan will define for you what mere association is. It's the old adage, who you hang around with. If you hang around with the kids, I was always told, if you hang around with the kids from the other side of the tracks, you're going to get in trouble. So don't hang out with them. But mere association is not sufficient. Who you hang out with, who you choose to be your girlfriend, your partner, spouse, that's not sufficient. Judge will tell you a jury is not authorized, you all, to find a person who was merely associated with other persons, Brittany, involved in the commission of a crime, guilty. Just who you choose to hang out with, just who you choose to be with, just who you choose to be in love with, associate with, is not enough. They, again, have to show you did something or helped in doing something in order to be guilty beyond a reasonable doubt. Malice murder, count 1, essentially with malice aforethought, those legal words that Ms. Nazan was talking about. Malice, bottom line, is the unlawful intention to kill. You unlawfully intended to kill Amari. That's what count 1 must be proven by the state by evidence beyond a reasonable doubt. It is not there that she unlawfully intended to kill Amari. The murder counts, felony murder counts. You have ag battery, ag assault, cruelty to children, all dealing with November. Not talking about July here, we're talking about November. And the state, beyond a reasonable doubt, must prove that Celeste caused the death of another person, Amari, by committing a felony, either ag battery or ag assault or cruelty to children. Again, they don't have to show malice, but what they do have to show is this person sitting over there who's been sitting next to me for 5 days, by evidence, killed Amari during a felony, or participated or assisted in Brittany killing Amari during the commission of a felony, by evidence. And ladies and gentlemen, they have not. And lastly, as I started off early on in my closing, ladies and gentlemen, Judge Duncan will tell you that your verdict should be a true verdict based upon your opinion of the, it's not going to say opening or closing statements of the lawyers. It's not going to say which lawyer or lawyers you liked or didn't like. Your verdict should be a true verdict based upon your opinion of the evidence, according to the laws given you in this charge. Judge Duncan will further tell you, you are not to show favor or sympathy to one party or the other. Brutally tough in a case like this, where you have an 8-year-old who's gone, who'll never see another birthday or Christmas or graduation or grow up. Yeah, it's brutal. Absolutely it's brutal. But when you swore your oath, that's what you swore to do. You are not to show favor or sympathy to one party or the other. Judge Duncan will tell you it is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. Extremely tough and brutal in a case like this. But that's why you all were chosen. because that's what you swore an oath to do, and Judge Duncan will tell you that. She'll lastly tell you, ladies and gentlemen, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, economic status, for or against either party. Quite simply, you take people as you find them. You take the evidence as you find them. You take the law as given to you by Judge Duncan, that she will tell you after we sit down. I don't get to come back up here and counter or refute anything that Ms. Nizam or Mr. Brown, either one of them, comes back here and says in closing. Now, sitting over there, I may go, oh, I should have covered that. Why didn't I cover that? But at the end of the day, the bottom line, ladies and gentlemen, is the state has the full, total, and complete burden of proof beyond a reasonable doubt to prove to you by evidence that Celeste Owens is guilty. And I submit to you, in regards to the particular case before y'all, the evidence that's been presented, that's not been presented, you never heard squat, jack about the crime lab. So none of those pillowcases, clothing, none of that stuff was ever sent off. Or if it was, never got any results back. Because if there had been blood in any of that stuff, I submit to you, you would have heard about it. But you don't have any of that before you. So what you have in this case, ladies and gentlemen, is supposition, is guesswork, is, well, this is from July, let's equate it now over to November. Guilty. I submit to you, ladies and gentlemen, please hold the state to their burden of proof, as the judge will tell you you must do. Render a verdict that speaks the truth in this case based upon the evidence and the lack thereof. Follow the judge's instructions regarding your duty and ask you to return a verdict of not guilty. Thank you.
Thank you, Mr. Greenwald. All right, ladies and gentlemen of the jury, I want everybody to stand up and stretch for a moment. Everybody good? And be seated when you're ready.
To believe that this defendant did not directly commit, help, or participate in the death of Amari Hall is to believe that essentially the defendant was tasked with caring for these children, being called their dad, being in a relationship with Brittany Owens, admitting in her interview with the police to living at the Congress Hotel, living at the Hometown Studios, to say that she had been in a relationship and had been getting to know the kids and being with the kids for going on 2 years, and that while all this is happening, she's just standing there watching. Just standing there, not doing anything other than watching Brittany Hall beat Amari. That's what she wants you to believe, and that's simply unbelievable. And the evidence is clear as to why that's unbelievable. And let's look at it now. So let's look at these videos. You see them, and it's hard to unsee them. But they saw it every day. She saw it every day. And the reason these videos are important, Detective Sorensen, said that they occurred over a range between July 20th and August 9th of 2021. That's when they were stamped. And the judge will also tell you that the date really doesn't matter, as long as it happens before the filing of the indictment. So we can pick a date, which was the first day, July 20th of 2021, but those videos occurred over a period of time. Detective Sorensen told you that, and the judge's law will also tell you that Dr. Downs said that this was a pattern of abuse that had occurred starting from anywhere between days to months, various stages of healing on all of these different injuries on Amari. So what happened at the Congress Hotel does matter. It matters a lot. And this defendant directly was abusing not just Amari, but all of the children. Call it luck that the detective found those videos, call it divine intervention. I don't know what it was, but we do know that it happened. Ms. Penix came in here to tell you that the Congress Hotel, that's located here in Gwinnett County, because we have to prove to you that it occurred here in Gwinnett. So that's why she came in here and to tell you that. And so these videos and the individuals on the videos, Sergeant Campbell, the reason he came in here and gave a big pamphlet of all the different tattoos that are found on both defendants is so you can decipher who is who on these videos and who is doing what to whom. Now remember, all the evidence that came in, you will have that with you. You will be able to take that back, the photographs, the charts, all the different things. You'll be able to look at that yourself. This is Celeste Owens. This tattoo, I submit to you, you will see several times on the videos. You will see her face on several of these videos. You will hear her voice, which you spent almost 2 hours listening to when she spoke to Detective Swarmson. And you'll know that she has no tattoos on her legs. So we know when there's a tattoo on the leg that it's going to be Brittany Hall. That's what Sergeant Campbell's purpose in coming to court to talk to you guys was about. And each of the counts in the bill of indictment, as they pertain to the cruelty to children charge, deal with the fact that we have to prove that this defendant, either individually, on her own, or as a party to a crime, either helping or being part of, remember, two people can commit the same crime, depending on the role that they play. Being there, having the same pattern of abuse, doing the same types of things, and being seen on video doing it, whether it was in July, August, or November, doesn't matter. Causing cruel and excessive physical and mental pain. So let's go straight to the point of what these videos were about. How humiliating.
Like this shit, sweet your ass, bitch. What is it? He is always from the church. So as you walk out, he
To call an 8-year-old that's just sheer humiliation, right? Mental pain, excessive mental pain. Count 8 charges both defendants, but again, we're here for her today, for slapping Amari, causing her head to whip back while sitting on the ground. Here's count 8. Guilty. Count 9. Kicking and striking Jakari while he's blindfolded and laying on the ground. That's the language in each of these counts that you'll get to take back with you. We have to prove that beyond a reasonable doubt.
don't move.
The tattoo on the arm, the voice, this defendant. Blindfolded children laying on the ground covered in blankets. This is not discipline. This is torture. This is humiliation. This is savage. Count 10. Stomping on Jakari while he's laying on the ground and telling him to go to the bathroom. Again, the language we have to prove beyond a reasonable doubt in count 10 of the indictment.
Let's go to the bathroom.
Guilty. And as an aside, remember Dr. Downs talking about Amari's lacerated liver? And how it could be caused by blunt force, flat surface like a foot hitting the floor, getting squeezed between the two?
move over. Put your arm down. Put it down. Go.
Guilty. Again, same manner in which Dr. Downs testified Amari's injuries could have occurred. Count 12, striking Jakari repeatedly while he's sitting on the floor wrapped in a sheet. Again, look at Zaire, blindfolded, staring at the wall with a sheet wrapped around her. She is 6 years old.
I know it's not for changing. Huh?
He's finna get smacked. First of all, he's finna get smacked now. I don't know if he's looking at me.
Hey, I'm finna handle it. Stop looking. Do you understand me? Keep your eyes to yourself. Do you understand? Stop looking. Stop looking.
I smacked earlier for that.
Guilty. Count 12. Count 13. There's that koi fish tattoo again. This defendant striking Jakari and stomping on him, just like Amari's lacerated liver, while laying on the ground, shirtless and blindfolded, telling him to go to sleep.
Go to sleep.
Another stump. Just like what Dr. Downs said, likely caused a lacerated liver. Count 14, repeatedly striking Jakari on the floor on the back while he's laying on the floor. Again, you don't see these kids sleeping on the bed much, do you? Guilty. Doesn't matter who's doing the slapping. They are parties to the crime, helping together, same manner. Count 15, repeatedly stomping on Jakari while he's laying on his stomach on the floor. Again.
You stupid as fuck.
Because it's not enough to stomp on him, you've got to call him stupid as fuck, too, pardon my language. Same type of stomping. Doesn't matter who pulled the trigger, doesn't matter who stomped on that liver that killed Amari eventually. Count 16, slapping Jakari multiple times while he was standing.
Right now. That's smack. Stop moving. On her.
Guilty. Doesn't matter who's doing the slapping. Count 17, striking Zaire with an unknown object while she's laying on the floor. I do want you to pay close attention to the second voice.
You heard me? I'm standing right here. You got this. I'm standing right there. Take it. Twice.
Talk about helping. You got this. I'm standing right here. Does that voice sound familiar? Guilty. Count 18. Stomping and kicking Zaire while she's on the floor and telling her to move the other way.
Turn the other way.
Guilty. Count 18. Why? Why would they? Why would That's why she didn't need the sheet. She didn't cover up Jakari. She just didn't want Zaire to have them. And why this?
Fuck your food. Turn around and put your hands up. I said swallow the food first, then take another bite because she's dropping mashed potatoes everywhere. And try to scoop it off the carpet with a spoon. Then I said stop. She stopped and finally trying to keep going after I said stop. So I'll slap her stupid ass. Oh. Tomato bust in my mouth and almost got on my face.
You can see her face there in the corner. You can hear her voice. Who else is she talking to? There's only two people, two adults who lived in that room. Helping, encouraging, directly participating. Turn around and put your hands up? Stare at the wall? She's 6 years old. Guilty of every single count of cruelty to children in this indictment that this defendant is charged with. So let's move on to what really matters. It all matters because it's all connected. It's all intertwined. The first count in count 2 of felony murder has what we call an underlying count of cruelty to children. The felony in the felony murder in count 2 is cruelty to children. For causing Amari, who is under 18, cruel and excessive physical and mental pain by causing multiple blunt force injuries to Amari. 11 pages of injuries. Weakened her body. Various stages of healing. Various different places on the body. Those 15 videos show us that they act together. They encourage each other. They help each other. They hurt these children in the same way. They blindfold these children in the same way. Causing a cruel, excessive physical and mental pain. And to believe that she just stood there and didn't do a damn thing is unbelievable. They're acting together. Amari is in the care of this defendant. She tells Detective Sorensen, yeah, we're there all the time, we're homebodies. The hours leading up to Amari, we know from investigator Wilbanks that this defendant was in the hometown studios. We know that the only time she left, and we contend that this happened on November 19th, because that's why the U-Haul was rented on November 19th. That's why she drove to the area where Amari was dumped. That's why we guilty of felony murder in count 2. She is guilty for causing the death of Amari through committing the act of cruelty to children. Guilty to count 2. Felony murder in count 3 deals with a charge called aggravated battery. There's a lot of charges because a lot of things happen to this little girl. And she commits the offense, and this is the language that you'll find that we have to prove to you, that she commits the offense of aggravated battery by maliciously causing bodily harm to Amari Hall by rendering a member of her body useless, specifically her liver. Now, useless is sort of a legal term. Obviously, when you sever or when you actually lacerate the liver, as Dr. Downs testified, it's no longer usable. In this case, it caused her death. It was one of the things that ultimately caused her death, not the only thing. In other words, the defendant's actions caused Amari to have a lacerated liver, which then ultimately, in relation to all the other things, caused her death. The stomping that you saw in the video, that likely caused it. That is the state's theory, based on what Dr. Downs had said. But again, put together with all the other injuries on that little girl, because that's what she was, a little girl. And it doesn't matter who inflicted it, because her actions, as you saw, helped cause the injury. And if you believe that she could have stomped on that child, hit that child, if you believe she could have lifted her hand to strike that child, based on everything that you now know, that she is a party to the crime, and she is guilty of felony murder by committing the offense of aggravated battery, that she helped, either directly or helped or encouraged that liver to be lacerated. She's guilty. She can be guilty of every single count. Remember, you don't have to pick and choose. Count 4, felony murder for aggravated assault. Aggravated assault is when you assault another person with an object, device, or instrument which you can use offensively against another person, and that it actually does cause injury or could cause injury. Again, lots of legal words for basically saying if you use something that could kill or seriously injure someone else, that is what's called an offensive instrument, an offensive object. And here in the indictment, the state alleges that we don't know exactly what it was. We don't know if it was a foot, we don't know if it was a hand, we don't know if it was a belt, we don't know what it was, because they were beating these children with hands, feet, some sort of whip type thing. And so we don't have to be able to show you exactly what that was. We can say that that object can be unknown, but it is likely that it was the hands and feet of this defendant and Brittany Hall, because they're both charged. But together, that caused these injuries to her. I apologize, there is a typo here, but when deciding whether or not something is offensive in some way, you can look at various different things. But essentially, if you find that this defendant utilized some sort of an object, whether it be hands or feet, that ultimately resulted in the injuries to Amari, that's aggravated assault, either directly by helping or causing it to happen, then she is guilty of felony murder, or the underlying offense of aggravated assault. Essentially, she is guilty of all the murders charged in the indictment. It is one death committed in multiple ways. And that's why there are numerous charges dealing with murder. And you can find her guilty of each of those ways of committing murder, because as Dr. Downs said, there was a lot of things that were done to Amari that caused her death, that she either helped with, encouraged, or directly participated in. So what happened to Amari? like that? Miss Wright told you this was taken in Miss Wright's house. The way Miss Wright always will remember Amari. Something happened, and it was likely an extension of all the things we've already seen and know. Maybe there was more beatings, maybe there was more blindfolding, more staring at the wall. Maybe it went too far. Maybe her little body, because it was little, couldn't take it anymore. The timeline, you will have all of this information with you. We've talked about it, you've heard the evidence, and you will have the information with you to go through. But what is very, very interesting, once again, is that in the search of this defendant's phone, all of these concerning searches that she did were deleted. Why? You don't want anybody to know that you're looking up how sewage drains work or how to find missing people. You don't want anybody to know that you're about to rent a U-Haul. Why? On November 19th, around 4 in the morning, something likely happened, whether it was a beating gone too far, that this defendant either directly committed, encouraged, participated in. Something happened, and that's why these searches on her phone, not Brittany Hall's phone, but her phone began. Interesting searches too. Why do you need to find a lake near her? Why do you need help finding missing people? Are you trying to dispose of a body? The state will submit to you that that's what happened. Amari is likely now dead, killed at the hands of this defendant. Now they've got to get rid of her. She's got to get rid of her. So she's got to figure out, well, what can I do? I don't have a car. I don't have any friends. I don't have any family, according to her. What can I do? Well, I better figure something out. I'll go and search up some great idea. And the searches begin. So she has to delete them in case anybody ever finds them, because they don't look good. Her movements are very telling. And again, you'll have the information. Detective Wilbanks did a fantastic job putting together all of her movements with the known information that we have. We know that on November 19th of 2021, this is why the state contends that Amari was killed on November 19th. Because at some point, early that morning before those searches started or around the time they started, and again, it doesn't matter what date it happened. We don't have to prove that, but the evidence shows that it's likely it happened on November 19th. Something happened and Amari is dead and the searches began. And ultimately the searches for U-Haul take her to the nearest U-Haul at around 1 o'clock. And you know from the surveillance video, where she is clearly seen, you know from the contract that she's put all her information on, you know from Detective Blackburn telling you that he sees the name of Celeste Owens on the caller ID of the U-Haul that she's calling, or someone's calling from that phone. Obviously it's got to be her, it's her phone. And you know from the photographs that are taken when the van is returned later that day, found on her phone, of her own driver's license, as well as the pictures of the U-Haul that is returned with the odometer, like you would do when you return a vehicle to make sure the tank is full or whatever you need to show. You see her leaving with the van that she has now rented around 1 o'clock in the afternoon, 1:13. And she stops at Family Dollar. And how interesting that what this defendant buys on video and through the receipt is bleach and latex gloves. You'll have the receipt with you. It says a pack of 4. CSI Johnson said they found 2 in the trash can at the hotel, double gloved. What happened to the other 2? Maybe in that backpack that the defendant is seen taking out of the U-Haul when she returns it that day, the black backpack, the same one the gun was found in at the hotel search. Leaves the Family Dollar around 1:40 videos and stays there until 5:50 when it gets dark. Why does a person who lives at the extended stay hotel without a car need to rent a U-Haul for 6 hours? Because this defendant is transporting Amari's dead body out of the room. That's why. And coincidentally, right around that same time, as Detective Wilbanks testified, that's when the preferences on the iPhone changed, where the location data is now turned on, so no one can track where she's going in a rented U-Haul for 6 hours on the day Amari is likely murdered. At 5:52, the video surveillance that you viewed with Detective Blackburn shows that the van is moved to a spot closer and backs in closer to room 251. At 5:52, around that time after backing in, the van leaves. I am now telling you the last moments of Amari leaving her home questioned by one of the most experienced defense attorneys in this jurisdiction. And for the first time in 3 years, she saw this woman. Had to be 20 feet away from her for the first time. That's one brave little girl. And what she tells you is that she ate bread. She tells you she looked at the wall, and we know she did. There were no toys, not in the search of the room, not when the officers got there, no books, no homeschooling. There's nothing going on. They were getting beat and staring at the wall and blindfolded when they weren't. Slept on the floor, no pillows. You saw it. And what she told you was that Amari was put into a container with a lid by this defendant and put into the trunk of a car taken to the hospital for bad kids. And that's corroborated by seeing the U-Haul. Why do you need to rent a U-Haul? They know they don't have a car. Zaire knew that. See, Amari's in a container being put in the back of a car in the trunk. That's corroborated by the fact that she had to rent a U-Haul to put Amari in the back to take her away. She says the man took Amari. Was that who she called Dad? It's a lie for her to come in here. So why did they even call the police? Because now they got to figure it out, right? They got to figure out what they're going to do. They have to call the police. They can't pretend Amari never existed because Papa and Gigi, Mrs. Wright and Mr. Wright, they weren't going to give up. They weren't going to stop looking for their grandchildren. They told you they drove around from place to place, from extended stay, from hotel, looking for their grandchildren. And they weren't going to stop. And they knew that. They knew the kids would probably ask about Amari. But they still waited 2 days so they could get their story straight until they called the police on the morning of the 21st. Because it gave them enough time for the search history around 3:43 on the 19th of how do I report someone missing and what to do when a loved one goes missing. They're trying to figure it out. They're trying to prepare. What am I going to tell the police? What do they want to know? And you can tell because in the interview with Detective Sorensen, when the defendant's getting real agitated there towards the end, because they keep asking her where Amari is, that's not what she was expecting. Based on her Google search, I submit to you, she was expecting, and this is what she said to them, this is how you go about things. You get info for the missing child that night, then you give a courtesy call, and then you take a statement. That's what she thought was going to happen based on her infinite knowledge from Google of how to report someone missing. And that's why she was getting agitated. She didn't think it'd be a big deal, I submit to you. In her initial statement to the police, well, Sergeant Forrester came in to tell you how calm everybody was. Nobody was erratic. And Jakari and Zaire were quiet the entire time, even amongst all of the commotion, all the police activity. Clearly they're in a bed then because the police are coming. You gonna blindfold your kids and put them on the ground when the police are at the door? No. You go to headquarters. She's still calm. She keeps saying, I'm not in custody, I'm free to leave. And she was. You could hear the detective say that to her. Because at that point, all they wanted to do was find Amari. That's the only thing that they want to. And then what she tells them is a bold-faced lie. She says, I didn't go anywhere November 19th. One of the many bold-faced lies, but she said, I didn't go anywhere November 19th of 2021, which we know is not true. Based on all the movements we just talked about, based on the plot, based on the surveillance video, based on the geolocation data. There's so many lies. I take her toys away and talk to her. So Amari, this is what she tells the detective in her statement when she's disciplining her. It never got physical. She would not hit the children. These are the things says Zaire fell off the bed since she's a wild sleeper. Amari hits herself in the face. How interesting, since the only video we have is of her slapping Amari, hitting her in the face. Amari and Zaire would fight, and that's not true because Zaire came and told you they got along. She doesn't know where Amari is. We know that's not true. She starts talking about these strange people at the hometown studio, some crackhead, and some lady with pimples on her face, and some guy walking around with a bin trying to pick up kids. Just lie after lie after lie, deception. And then she tells you she's with Diamond that night, the night before. My sister picked me up. I spent the night with my niece and nephew. Was there from midnight till 4 or 5 in the morning. Her own sister came in here and took the stand and said, no, that was a lie. She's guilty of making a false statement to Detective Sorensen by saying that she was with Diamond Owens at a time that was relevant in her investigation. That's count 21. She's guilty of that. And then all of a sudden there's a drastic shift in her demeanor, as you saw, ending with "you're a piece of shit" to Detective Sorensen. Based on the fact that now she realizes the gig's up. They're not just taking a statement like Google said they would and making a courtesy call. Now they're going to go through her phone. Now they've talked to her family. Now everything changes. She's not that worried about Amari through that entire conversation. She only gets emotional when she realizes the gig's about up. And the phone, first she's fine, because in her mind she's deleted all her history. She's deleted all the stuff that matters. Probably forgot about the videos that are still there. She knew she turned off her location information. And then when she realizes, okay, well, maybe they're not as dumb as I think they are, then all she wants is her phone back. I just want to get my phone and leave. I want to get my phone and leave. That's what she tells the detective in the interviews. Mr. Greenwald talked about no DNA. I want to touch on both things. You heard that there was a search of the U-Haul for any kind of odor of a cadaver. And I want to make it very, very clear that there are some very logical reasons as to why the cadaver dog, whose first search it was, or second search it was, would not have hit on any kind of odor. And because we do believe Amari was carried in the back of that U-Haul van. And she told you, Ms. Schwartz told you, that the length of time in the back plays a big factor, that she would have only been in there less than an hour in the back, maybe in a container, but clearly in garbage bags, because that's where she was found, wrapped in garbage bags. And you can see in the crime scene photo that you'll have with you, there's a bag of Glad garbage bags, and they say leak-proof and neutralizes odor. We know she bought some bleach. Maybe she cleaned it. She had the backpack. And the DNA? You're right, the DNA wasn't tested because there wasn't anything to show. The DNA would show who was in the room. We knew who was in the room. We knew it was all 4 of them. That's not going to tell us whether or not this defendant participated, helped, or directly committed blunt force injuries and lacerated liver to Amari. That's not this kind of case. So why? Why do this to these children? I don't know. Maybe they're an interference to the relationship. Maybe she doesn't know what to do with the kids. Maybe Amari was wetting the bed. She didn't really care about the impact that this type of behavior had on the other kids. This wasn't discipline. This wasn't anger. This was control. This was torture. These kids weren't doing anything. You saw in these videos, they're sitting there quietly. They're getting beat. Nothing that causes for anything like this to happen to them. We don't need to prove motive, the judge will tell you. But there is no reason, which is what makes it so much worse. And this was intentional. I want to point out something that is very relevant. The reason that we put in the weight of this defendant and Zaire and Jakari were likely less than that. That kind of force, that kind of weight on top of those children, and Amari was already weak. That's why they were kept out of school. They had no friends. Those children sat there staring at the wall and having no idea that their Gigi and their Papa were out there looking for them. They had no idea the world was happening around them while they sat in that hellhole with her. You saw the injuries on Zaire the night that the police brought them to headquarters. Look at her little extended belly. Her face. Remember Dr. Downs talking about the scars and the various different things on Amari? The scabs, various stages of healing. Same thing with Jakari. Those defensive wounds that Amari had on her arms. That's Jakari. His back, his hand, his extended belly. Randy Work said that in his experience with special victims, that's usually associated with not getting enough food. And this was purposeful. It was purposeful because she deprived them of food. There was plenty of food in that little hotel room. She was eating it. So was Brittany Hall. There was food everywhere in that hotel room, except for Amari, Jakari, and Zaire. Battered child syndrome, based on Dr. Downs' testimony, indicates there were so many different, multiple fractures that were caused over a period of time, different places throughout the body, weakened her body, along with the fact Amari's body, without having any food, she weighed less than the 5th percentile, no muscle development, said she was respectful. She loved to dress up. She loved to cook. She let her crack an egg in the cornbread. Amari will always be 8 years old. This defendant took this Amari and did this to her. He took everything from her. She loved to dress up, so she left her naked. She loved her hair, so they cut it off. Zaire said, Celeste cut it off. They didn't even put clothes on her. They didn't put her glasses on her. She loved to cook, so they starved her. When I say they, that's she. When I say she, it's they. They did this together. Doesn't matter, but today's her day. She treated her like trash. But Amari Hall was anything but trash. She was a little girl. A little girl who didn't have anywhere else to go in her life. And she killed her. Ladies and gentlemen, the standards that we set for this community, the community that each of you have said you have chosen to live in, raise your children in, buy your homes in, work in. This community, the standards that are set in this community, what is acceptable and what is not acceptable in this community, it is not set by this honorable court or the district attorney's office or the Gwinnett County Police Department. It is set by all of you, each and every one of you, who in this moment in time will make one of the most important decisions that you will ever make within these hallowed halls of justice. Because today, the power shifts. This woman had the power over Amari for a long time, but today it shifts. It shifts here to you. The Gwinnett County Police Department knocked on every single door of the hometown studios looking for Amari. There is one door left, and that's this door. Right here. That leads into courtroom 204. That leads to you. Today is that day. She no longer has the power. This defendant is guilty of every single count, and I ask you to find her guilty on all counts. Thank you.
All right, ladies and gentlemen of the jury, is everybody good? You need a restroom break? Okay. All right, we're going to take a 10-minute recess. We'll come back for the charge of the court. All right, anything to take up outside the presence of the jury?
Not for the state judge.
Mr. Greenwood?
You let them know, Judge, that, I mean, I know everything goes back with them, but obviously there's no mechanism for playing stuff. Just so that they know there's nothing for playing, any videos or anything.
Well, none of that goes back with them if they want to see any of that. So you want me to let them know that if they want to see a video or listen to anything again, they can ask?
Sure.
That's fine, Judge.
I will try to remember that. The court has provided you with the final charge of the court. Any exceptions
Just,
No.
other than already noted for the record?
is this the final?
This is the final.
No objection for the state judge.
Ms. Owens? Yes, please.
And we've separated piles, Judge. We did what stays here, what goes back.
And we'll put that on the record before it goes upstairs.
Yes, Judge.
We're gonna wait for Ms. Owens, so that's fine. We can do that. All right. With the defendant now present, what did you want me to explain to the jurors? Oh, about the videos.
Videos. That doesn't go back with them. They can watch it back in the court. What is it, the interview and then the surveillance cameras from you all and all that?
Yes, it's just surveillance cameras.
I know everybody.
Yes,
That's the.
yes.
So it's like, her interview, Judge, the surveillance from the store.
There's also a disc with the videos of the individual videos.
Right.
Ms. Nazam, Mr. Greenwald, would you guys like to go ahead and put on the record what is and what is not going back with the jury?
Sure.
The exhibits? Don't distract him.
I just
We're
literally.
just gonna sneak.
He did it last time.
Well, that's me.
Yes, that's
Go
right.
ahead.
15 more
Sorry,
minutes.
sorry, it's official.
Sorry, go ahead.
All right. This is, we don't do it any other way. Judge, we can just go, it might be easier to put on the record what is not going back unless you would like everything on the record.
That's fine.
Okay? Judge, States Exhibit 100, 101, 112, 114, 116, 118, 20, 71, 21.
And those were for the record only,
Okay,
Judge.
yes.
So what she's about to go into is in evidence, but if they want to see it, come back in court.
Yes,
I just
Judge.
for record purposes.
And also for the record, States Exhibit 21 is a flash drive. And States Exhibits 27 through 41 are contained on one specific CD. States 119, 115, 26, and 102 are individual DVD discs. And then States Exhibit 26A is a flash drive. So those would not go back with the jury and everything else would. Is that right, Mr. Greenwald?
Yes, except Brian and I put them in his file so that if the jury wants to see or hear anything,
Got it.
you know, this,
Yes.
they can see this.
Maybe we can just put this over here, just in case.
So, we're in agreement, Judge.
That's evidence purposes only, have that one separate, correct?
Yes, Judge.
All right, it is noted for the record. Are you ready for the jurors?
State's ready, Judge.
Yes, sir.
All right, we have the jurors, please.
I was so close.
Sorry.
Be seated. All right, ladies and gentlemen of the jury, first let me say thank you all for your time and attention over the last week. It is very much appreciated by both parties and the court. What I'm now going to do is read to you what is called as the charge of the court, and that's basically where I go over the law that applies to this case. Ladies and gentlemen, you are considering the case of the state of Georgia versus Celeste Alexandria Owens. The grand jury has indicted the defendant with the offenses of malice murder, felony murder, cruelty to children in the first degree, aggravated battery, aggravated assault, concealing the death of another, and making a false statement. The indictment states the exact offense or offenses which have been alleged by the state. You will recall that the indictment was read to you at the beginning of the trial, and it will be out with you as you deliberate. You are instructed to read it carefully and examine it for yourself. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations that have been approved by the court about facts and exhibits that are identified in documents titled Stipulations for Trial and Additional Stipulation for Trial that will be provided to you for your deliberations. Where the parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. When parties stipulate testimony, documents, and/or exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence, or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not a common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it properly entitled to receive. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence, For any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of her constitutional rights. To be voluntary, a statement must be freely and willingly given, and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had the right to remain silent. 2, if the defendant chose not to remain silent, anything she said could be used as evidence against the defendant in court. 3, the defendant had the right to consult a lawyer before any questioning and to have the lawyer present with her at all times during any questions. And 4, if the defendant did not have the money for a lawyer would have been provided for her to represent her before any questioning and to be present with her during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching the verdict. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of the state in which there is a joint operation of an act or omission to act and intention or criminal negligence. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person A, directly commits the offense, B, intentionally helps in the commission of the crime. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted. Knowledge on the part of the defendant that the crimes of malice murder, felony murder, cruelty to children in the first degree, aggravated battery, aggravated assault, concealing the death of another, and making a false statement were being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find, beyond a reasonable doubt, that the defendant had knowledge that the crimes of malice murder, felony murder, cruelty to children in the first degree, aggravated battery, aggravated assault, concealing the death of another, and making a false statement were being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that certain criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Gwinnett County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. The defendant is charged in count 1 of the indictment with the offense of malice murder. For malice murder, the state must prove that the defendant, 1, caused the death of another, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The defendant is charged in counts 2 through 4 of the indictment with the offenses of felony murder. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Cruelty to children in the first degree, aggravated battery, and aggravated assault are felonies, which I will define for you shortly. One second. You may find that the defendant is guilty of felony murder if you believe that she caused the death of another person by committing the felony of cruelty to children in the first degree in count 2 and or aggravated battery in count 3 and/or aggravated assault in count 4, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must directly cause the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. The defendant is charged in counts 5 and counts 8 through 18 of the indictment with the offense of cruelty to children in the first degree. For cruelty to children in the first degree, the state must prove that the defendant 1. Maliciously caused, 2. Cruel and excessive, 3. Physical and mental pain, 4. To a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice, in this context, means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. The defendant is charged in count 6 of the indictment with the offense of aggravated battery. For aggravated battery, the state must prove that the defendant 1. Maliciously caused bodily harm to another person, 2. By rendering a part of that person's body useless. In deciding whether or not the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. The defendant is charged in count 7 of the indictment with the offense of aggravated assault. For aggravated assault, the state must prove that the defendant 1. Assaulted another person, and 2. With an object, device, or instrument, when used offensively against a person, is likely to or actually does result in serious bodily injury. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. An object, device, or instrument, when used offensively against a person that is likely to or actually does result in serious bodily injury, is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether an object, device, or instrument is an offensive weapon, you may consider all of the following factors: the nature and extent of any injury inflicted, the manner in which an object, device, or instrument was used, and any other circumstance of the case. Although hands and feet are not deadly weapons per se, they may or may not be deadly weapons depending upon the manner in which they are used and the circumstances of the case. Whether hands and feet, if used, constitute weapons in this case are facts solely for your determination. The defendant is charged in count 19 of the indictment with the offense of concealing the death of another. For concealing the death of another, the state must prove that the defendant 1. Concealed the death of another, 2. Which hindered the discovery of whether that person was unlawfully killed. The defendant is charged in count 21 of the indictment with the offense of making a false statement. For making a false statement, the state must prove that the defendant knowingly and willfully made a false statement in any manner within the jurisdiction of any department or agency of the government of any county. If, after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County, Georgia, did on or about November 19, 2021, commit the offense of malice murder, felony murder, cruelty to children in the first degree as to count 5, aggravated battery, aggravated assault, and/or concealing the death of another, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Gwinnett County did on or about July 20th of 2021 commit the offense of cruelty to children in the first degree as to counts 8 through 18, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe, beyond a reasonable doubt, that the defendant in Gwinnett County, Georgia, did on or about November 21st, 2021, commit the offense of making a false statement as to count 21, as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of any of these offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. I have prepared a verdict form for your use that will provide you with the space to record your verdict. The indictment in this case does not state the date of the offense the indictment in this case does not state the date of the offense as a material averment or element. Therefore, it is sufficient that the state shows that the offense occurred prior to the filing of the indictment, regardless of the date listed in the indictment. Ladies and gentlemen, by no ruling or comment that the court has made during the progress of the trial has this court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to any other party or the other. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messages, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as a foreperson, dated and returned to be published in open court. Any communication with the court should be made in writing and signed and dated by the foreperson. Ladies and gentlemen, we can only allow 12 persons to deliberate the case, so the bailiffs are instructed to keep the alternate jurors in a separate room or area. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence that has been admitted in the case. Ladies and gentlemen, you will be provided with most of the evidence in this case to go back with you in the jury room. However, the DVDs and thumb drives and things of that nature do not go with you back in the jury room. If at any point in time you need to see any videos, then you are to let the bailiffs know. You would come back into the courtroom and it would then be played for you at that time. Some documents were only admitted for record purposes only, and those do not go back with you as well. I am going to provide the jurors, I will provide you all with the stipulations, and I will provide you all with the charge of the court that I just gave you. Okay. Any exceptions to the charge of the court?
Not from the state, Judge.
Mr. Greenwood?
Just add the verdict form.
Oh, and I also have the verdict form for you guys. Okay. All right, ladies and gentlemen, you can go to the deliberation room. They can either go downstairs in jury assembly or. We don't know who they are. Oh, okay. I'll tell you. All right, alternates are Andrew Lordy and Onike Manzaba.
48 and 50.
And if that was caught on the recording. Ms. Owens?
Yes, sir.
Ms. Barnes, do you have both of the alternates as well?
Yes.
Are we ready for the jury?
Yes, Judge.
Yes, sir.
All right, the foreperson. All right, sir, has the jury reached a verdict?
Yes, we have, Your Honor.
Was it unanimous?
Yes, ma'am.
Has the verdict form been filled in and signed and dated by you?
Yes, ma'am.
All right, Ms. Barnes? Counsel the first, please. Any objections to the form of the verdict?
Not from the state, Your Honor.
No, Your Honor.
All right, Ms. Owens, will you please rise? In the Superior Court of Gwinnett County, State of Georgia, in the matter of the State of Georgia versus Celeste Alexandria Owens, indictment number 24B03590-11, verdict of the jury. We, the jury, find the defendant as follows. Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, felony murder, guilty. Count 4, felony murder, guilty. Count 5, cruelty to children in the first degree, guilty. Count 6, aggravated battery, guilty. Count 7, aggravated assault, guilty. Count 8, cruelty to children in the first degree, guilty. Count 9, cruelty to children in the first degree, guilty. Count 10, cruelty to children in the first degree, guilty. Count 11, cruelty to children in the first degree, guilty. Count 12, cruelty to children in the first degree, guilty. Count 13, cruelty to children in the first degree, guilty. Count 14, cruelty to children in the first degree, guilty. Count 15, cruelty to children in the first degree, guilty. Count 16, cruelty to children in the first degree, guilty. Count 17, cruelty to children in the first degree, guilty. Count 18, cruelty to children in the first degree, guilty. Count 19, concealing the death of another, guilty. And count 21, making a false statement, guilty. Signed and dated this 13th day of December 2024 by the foreperson. You may be seated. Is the state ready to move for sentencing?
The state is ready, Your Honor. If I may have a moment to confirm with the family, I do believe they'd like to address the court at the appropriate time.
Before we do that, we request the polling.
All right, very good. All right, ladies and gentlemen of the jury, the defense has requested a polling of the jury. What I'm going to have you do is starting with the foreperson, because I'm not sure what order you guys are standing in. So I'm just going to have you stand up one by one in the first row all the way down, and then we'll start with the second row, excluding the alternates, of course. All right, sir, your juror number 17, is that correct?
Yes, ma'am.
All right. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you, sir. You could be seated. Can you tell me your juror number, please?
16.
All right, juror number 16. Was that your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Thank you. What's your juror number, please?
2, I think.
All right, juror number 2. Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you, sir.
18.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you, ma'am.
Juror 19.
Juror 19, was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you, sir.
Number 24, Your Honor.
Thank you, ma'am. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you.
Number 25.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you, ma'am.
Number 30.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you, ma'am.
Juror 36.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
And is it still your verdict?
It is.
Thank you.
Juror 37.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you.
Juror 41.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
And is it still your verdict?
Yes, ma'am.
Thank you.
45.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
It is.
All right, thank you. That concludes the polling. All right, ladies and gentlemen of the jury, at this time, I want to say thank you for your service, for your time and dedication over the last week. Obviously, this is not an easy case to sit, see, hear, and experience. And I know that I speak for both the state and the defense when I say thank you for your time and attention. This is a duty that is devolved upon us, and it is our responsibility and duty as citizens of Gwinnett County and of the United States. And it is a duty that is devolved upon us by the laws of this nation. And nobody ever wants to get that letter in the mail when they get it, but it is a duty that is honored and respect, and it's what sets this criminal justice system apart from all the other countries. And so I just want to say thank you guys so much for your service and your time. Now, I am now going to release you from the prohibition about looking anything up, or reading anything, or discussing this case. You are free to do this from this moment on. I will also tell you that a lot of times, I remember when I was a practicing attorney and I had jury trials, it always helped me to be able to speak with my jury afterwards. So you are free to do that. When we're done with sentencing, if you see them, a lot of times the attorneys sometimes will come down to jury assembly, and if you are willing to speak with them, you may. If you don't want to, you don't have to either. Okay? So, Ms. Barnes, will you please take them to the jury room? take a 10-minute recess and then we'll move to sentencing.
Yes, Your Honor, thank you.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the